Unmuted.
ಈಗ ತಾನಲ್ಲ ಆಯ್ತಾನೆ ಇಲ್ಲ ಇಯರ್ಫೋನ್ ಹಾಕಲ್ಲ
Nam page with advance implementation.
ಏನ್ ನಡೀತಿರುವಂಗದ ಇರ್ಲಿ
ಇರಲ್ಲ ಸರ್ ಹಂಗಾಗಿ ಇದು ಕೇಳ್ಬಾರ್ದು ಸರ್. ಹಾಂ ಸರ್ ಹಾಂ ಸರ್
ಏನ ಸರಿ ಇಲ್ಲ.
ಮನೆಗೆ ಬಂದು ಹೋಗ.
ಏನ್ ನಾಳೆ ಕೂಗ ಆಗೋಯ್ತು ಅಂತ ಕಾಣ್ತದೆ.
ಕೂಗುದು ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ, ಏನು ಇಲ್ಲ ಅಲ್ಲಿ ಕೂತಿರೋದು. ಇಲ್ಲಿ ಬಂದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋರು ಮಾಡ್ತಾರೆ, ಬೇರೆ ಏನೋ ಹೇಳ್ಬಿಟ್ಟು ಹೋಯ್ತಾರ. ಅಲ್ಲ
ಬಂದ್ರು ಈಗ ಅಂತ ಕಾಣ್ಸುತ್ತೆ.
ಹಾ
Yes.
But now it is ready to process my lord eviction, an eviction notice, directing me to evict within 3 days, saying that I deviated from the plan sanction. And I am in occupation since 2011 months. Erstwhile owners, please,
See, petitioner blood is a senior citizen, retired age of 76 years. Blood is a village house property. From past 70 years, blood, we have been paying the tax. My husband died, blood, I gave a representation. Please change the Kata because the property is required. Monday to
Kata transfer.
Settlements. Page number 8, serial number 48 and 49.
You are appearing for respond number 4. Have you informed the respond number 1 and 2? What? 16 Jan.
Number 10.
Inform ಮಾಡಿದೀರಾ? 58 at the request of counsel for the petitioner released on 16th January.
Number 61 to 68.
Serial number 63, paper dedication.
Inform the area.
At the request of counsel for the petitioner released on 19th January. This number 70. Yes. 3U4.
86
Inform the respondents, all of them. A request of counsel released on 19 January, interim order earlier granted is extended to next day.
Defendant also denies the sister in law.
The petition released on 19 January. Order earlier granted is
Petitioner has been informed. I pray for time.
the request to come for filing objections.
Yes, sir. I apply for art.
3.5 request for and is granted 3 weeks time to file a statement of January released on 19th.
Photo ಬಂದೆ.
77 readings are complete. Akidara. Counsel for the petition seeks for a short accommodation released on 19th January. In the meanwhile, objections to be filed by the counsel for respond number. For the petition, we inform the respondent. Harish N. Antidare. We inform.
ಅಲ್ಲ 77 ಆದ್ರೆ I'm there for the
7 Mr. Harish. 89.
My lords,
77 I want ಅದು ಯಾವುದು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. I'm sorry, we missed the page number because it was not audible. In 77 I seek an adjournment, short accommodation.
You inform the petitioner and respondents.
Yes, I have done.
77 Shri B.S. Satyanand has entered appearance for respond 1 and 2. Delete name of Shri V. Srinidhi as that appearing for respond number 1 and 2. Shri N. Harish, Learned Counsel for respond number 3 seeks for and is granted 4 weeks time to file a statement of objection. Objection is finished by 12, released on 19th.
serial number 88, my lords. 88, please, my lord.
My lord, 86, Your Honor. My lord, serial number 86.
86.
My lord, 86, Your Honor. Petitioner. Press 2 weeks times, Your Honor.
So 870726 until there. Why don't you put in your name properly?
Second case.
86, the 3337, sorry.
ಆಯ್ತಪ್ಪ ನಿಮ್ಮ when you're logged in videoಗೆ ಹೆಸರು ಹಾಕೊಳ್ಳಿ. At the request of counsel. Inform ಮಾಡಿದಾರೆ respondent ಗೆ. Respondent inform ಮಾಡಿದೀರಾ? Have you informed the respondent?
Yes, Your Honor. Yes, my lord. Inform. 86.
Counsel for the petition released on 19 January.
88, my lords. 88, my lords. I've informed the other side, my lords. 88, please, my lords.
The serial number 94 block. Pleadings, terms for petition of pleadings are not completed. I'm seeking for a 2 weeks time. Inform that I respond.
That counsel for the petition seeks for a short accommodation released on 22nd January. In the meanwhile,
Interim order.
objections to be filed. Interim order earlier. 91. Yes. Inform ಮಾಡಿದೀರಾ? PJ ಸೌಮ್ಯಾಜಿ ಇದ್ದಾರೆ. ಮಾಡಿದೀರಾ? ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ don't mention.
My lords, 88 has been done. 88, my lords.
88 is adjourned.
Yes, please, my lords.
Serial number 95 to 99.
Serial number 96.
Yes. Who wants time? Have you filed your objections? 96 at the request of counsel for the petition released on 22nd. Statement of objection by respondent counsel should be filed on or before 12 January. Interim order earlier granted is extended next. Serial number 4. Yes. 4. Counsel for respondent number 2 seeks for and is granted 4 weeks time to file a statement of objection. Objections, if any, by 12 January, released on 22nd January. Fifth time, Mr. ಇವತ್ತು ಏನ್ ಮಾಡ್ತೀರೋ ಇವತ್ತು ಮಾಡಿ ಇಲ್ಲಾಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಆಗಿ. Whatever you have to do today. Fifth time ಬಂದಿದೆ. ಮಾಡಿ. To be there, ಮಾಡಿದ್ಮೇಲೆ your colleague can make a submission, ನೀವು ಬರೋದೇನ್ ಬೇಕಾಗಿಲ್ಲ. ಇಲ್ಲ Janet, but it should be done.
Serial number 2. Not the R2 may not the notice as written as unclaimed. This number 2 may not serial number 2.
Serial number 2.
Don't hold it sufficient. Unclaimed is not sufficient.
Six not. Again,
Counsel for the petition seeks for and is granted weeks time to make payment of necessary process fee in respect to unserved respond number 4. Issue no you.
And I appear for,
Respond number.
I appear for petitioner.
That either list 2 idu.
Number 2.
List 2 serial number 2. You notice to respond number 2 written by.
But the never put that 2.
Entry order earlier granted is extended.
number 4.
Respond number 4 written by 2nd February.
63 my lord.
63 ಎಲ್ಲ ಒಂದು ಈ ಲಿಸ್ಟ್ ಆಯ್ತಾ? 63.
Yeah, to open the restaurant yesterday, my lordship. Only the permission can be given for bakery. And
Oh, this is what you had moved.
On the way.
63 released on in December.
it can be an order hearing. There is IV also pending hearing and IV.
Hearing of items.
Yeah.
And the last petition is just stated that the petitioner has to show an application.
Respond number 2 has expired.
Yes. I have to because of the petition. And this is directly, not directly to the.
Despite the order dated 6/11/2023, no action has been taken. None appears for the petitioner even today. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Memo for retirement.
Right.
ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಪೆಂಡಿಂಗ್.
ಮತ್ತೆ memo of retirement ಇದ್ದಾವ.
We got 2 now. It was smart. Pass over. Serial number 1 pass.
Lord, I appear for
Yes, ಏನಾಯ್ತು?
the respondent in serial number 1.
Regard to the next site number 313 is vacant not included.
That I put up a client because 300 meters is not bill. 300 spaces in that that is what I told you. But I convince my client.
ಏನೋ ಬರ್ತಾ ಇದೆ ಇಲ್ಲ ಅದನ್ನು ಹೋಗುತ್ತೆ.
Can't match the dimension because we don't form that kind of dimension of the site, and it is a well-developed area where the site is being allowed.
Counsel for the counsel for the respondent number 1 and 2 has filed a memo enclosing a communication addressed by the Commissioner Muda to him, indicating that site number 313 could be allotted to.
They have said it is vacant. It's vacant flood.
Vacant ಅಂದ್ರೆ allotment ಇದೆಯೋ ಇಲ್ವೋ?
It is vacant and unallotted. It is available for allotment, but they have not indicated that this could be allotted.
That site number 313 in the very same layout is vacant and unallotted. Learned counsel for respond number 6 seeks for and is granted a week's time to obtain instructions from our client as to whether respond number 6 is agreeable for site number 313 to be allotted in lieu of as an alternate site. Relist on 11th. 11th, Mr. Bhairappa.
11th.
11th. Annondu. One identify 313 and it's
Yes.
Yes. When did you file it? Yes. Also is not well. We'll allow this IA 1 of 2023 has been filed to place on record certain additional documents. Accepting the reasons stated therein, the said application is allowed, the documents are taken on record. Counsel for the petition seeks for and is granted a week's time. Relist on 14th December. Yes. It's set the adjournment of I do. ಈ ಸತಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದೆ 2018 ಮ್ಯಾಟರ್. The matter has been adjourned 5 times already for arguments for filing of amendment application. Even today, a short adjournment is sought for. In the interest of justice, relist on 7th December. If by that date the application is not filed, the petition will be liable to be dismissed for non-prosecution. Memo that counsel for the petitioner has filed a memo dated so and so signed by the counsel for the petitioner seeking permission to withdraw the above petition. Accepting the said memo, petition stands dismissed as withdrawn, pending application stand dismissed. Sadashivaya. Pass over.
My lords, I appear for the petitioner in this matter, my lords.
Yes.
My lords, looking into the tracking record available on the net, my lord, I made a submission that a notice has been served to respondent number 2. But later it is found by mistake they have.
Yes. Really?
By mistake it is reflected, my lord. The office had intimated me to serve fresh process, my lord, to pay the fresh process. As such, I would be doing it today, my lord.
Great. Learned counsel for the petition submit that you would make payment of necessary process fee and furnish copies for service with notice to respond number 2 by end of day tomorrow.
Interim order may be extended, my lord.
Registry is directed to issue notice to respond number 2, returnable by 6th February. Interim order earlier granted is extended till next day. IA 1 of 21 is dispensation. So you are not going to press IA 1. Nandish Patil, learned counsel for the petition, submits that he does not wish to press IA 1 of 2021. As such, IA 1 of 2021 is dismissed as not pressed. Yes. Amaleno. Mr. Gangadharappa.
They issued a notice.
The
property in question was purchased by the grandfather of the petitioner by way of the state.
Objections have not been filed. Counsel for respondent. is granted 3 weeks time to file a statement of objection, objections if any, by 12th January. If objections, if not filed by then, it will be taken as not filed. Relist on 18th. Interim order earlier granted is extended till next date. Can I give it? Yeah. 24 process fee output. So notice has to go on IA 1 to 3 also.
Yes. So I have taken the steps, madam.
And what is this affidavit to be filed, Soumyaji? But ಸಾಕು ಇನ್ಮೇಲೆ ಕೊಡ್ತಾರಲ್ಲ ಇನ್ಮೇಲೆ ವಕಾಲತ್ ಕೊಡ್ತಾರಂತಲ್ಲ affidavit.
I appear for lots of RPI and ARPO.
Any objections?
I have already filed my counter as directed by the Lordship within 1/12/2020. Like for a LR application is concerned, I have no objection.
No objection. We'll allow that.
Yes. LRs of RP and ARPO.
The counsel for response.
Petition Millard in the cause this period is shown as wakalat not filed. I have pointed out in the last occasion my wakalat is not filed. This will be directed.
We'll check that. The counsel for respond number 1 and 2 has filed the affidavit of the Panchayat Development Officer, Surikunte Gram Panchayat. Is not available under Ian Artha Soumyaji. ಏನು ಸಿಸ್ಟಮ್ ಇಲ್ವಾ ಅವ್ರ ಆಫೀಸ್ ಅಲ್ಲಿ ಇನ್ವರ್ಡ್ ರಿಜಿಸ್ಟರ್ ಏನು ಇಲ್ವಾ ಮಾಡಲ್ವಾ ಆರ್ ದೇ ಮೇಂಟೈನಿಂಗ್ ಇನ್ವರ್ಡ್ ರಿಜಿಸ್ಟರ್ ಆರ್ ನೋ can you not maintain a inward and outward register? ಏನ್ ದಿನಕ್ಕೆ ಒಂದೊಂದು ಬರ್ತಾ ಇದೆ ಇನ್ವರ್ಡ್ ಔಟ್ವರ್ಡ್ ರಿಜಿಸ್ಟರ್ ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಎಂತದ್ದು I don't know what happened. We have not received. When counsel for respond number 1 and 2 has filed the affidavit of the Panchayat Development Officer Surikunte Gram Panchayat stating that copy of the writ petition notice issued by this court is not available in his office. And it's only when his counsel was directed to take notice that he came to know about it. It is rather shocking that no inward or outward register is maintained at the Panchayat. Which is a basic requirement for all panchayats to maintain to ascertain the incoming postal documents and other documents and by other means. Shri Vijay Soumyaji submits that henceforth a proper inward and outward register would be maintained at the panchayat's office. It will be ridiculous to issue any direction. It's a simple direction. It's so ridiculous for a direction to be issued. CCMS baratte. CCMS bandre it will be good. How many directions? His submission is taken on record. Shri K.R. Nagaraja, who has entered appearance for the legal heirs of respond number 3, namely R3A to E, submit that he has no objection for IA 1 to 3 of 2023 to be allowed. During the pendency of the above matter, respondent number 3 expired on petitioner. Okay, sorry. During the pendency of the above matter, the petitioner expired on the date of 14/1/2023. Hence, IA 1 of 23 has been filed on 8/11/23 to condone the delay of 150 days. Accepting the reasons stated therein, and since there is no objection on part of the council for respondent number 3A to E and 4, the said delay is condoned. Consequently, the abatement in respect of petitioner is set aside, and by allowing IA 3 of 2023, the persons named therein are brought on record as petition number 1A to 1E. Counsel for the petitioner to carry out necessary amendment and file amended cause title. Awaiting notice. Await.
They are also they are refused to say the Vangala. That is the reason they compelled to make all these people.
They don't want to collusion, nah? Okay. Collusion, but a cooperation with respondent number 3.
I don't think so.
Awaiting service on respondent number 5 to 8. We list on
that I have filed the counter.
We list on 12th January. Registry to Sri K.R. Nagaraja submit that he has already filed his Wakalatnama. Registry to verify and correct the endorsement in the contract. Not to end. Suresh. You appear for whom, madam? Respondent number 1. Pass over. Post before a bench of which SGRJ is not a party. Yes. Nothing survives. But this would have to be published, Allah, Mr. Mesh. Publication agidya. In the 40 meter cutter. The counsel for respondent number 2 has filed a memo enclosing a letter issued by the commissioner, respondent number 2, him, indicating that the state government has approved the recommendation made by respondent number 2 to reduce the building line from 75 meters to 40 meters. His further submission is that if all other requirements are fulfilled, the application filed by the petitioner would be considered with the aforesaid building line restriction of 40 meters. His submission is placed on record. Separate application has to be filed. Petitioner is before this court seeking for the following reliefs on that to harmony that. In view of the said submission, the amendment having been made to the Master Plan 2021, there would be no requirement for issuance of a certiorari as sought for by the petitioner. The petitioner is permitted to file a fresh plan by showing the now amended building line requirements, which shall be considered by the respondents in accordance with law within a period of 90 days from the date of submission.
Your Lordship, my Lord, I beg to appear in serial number 10, my Lord.
Not before me, Mr. Reddy.
Please, my Lord. Objection.
Undena, that's the only objection. That counsel for the petitioner submit that court fee has been paid. Copy bandidya? Have you received the copies? Objections any? Objections idya? I'll argue. You want to file objections or you will argue? You want to file objections. Counsel for respondent number 1, 2, 3 seeks for and is granted 4 weeks time to file his objection. Objections, if any, by 12th, relist on 18th. Yes, Mr. Jagdishwara.
These records are not required. The Kata is subject to the name of the respondent. My friend has started from the respondent.
ನೋಡಿದ್ದೀರಾ ರೆಕಾರ್ಡ್ಸ್?
Petitioner is Kata change ಮಾಡಿದೀನಿ based on the application. Conditional Kata issue. After that, I spoke respondent for the right to reporting date. So issuing a notice to both the parties of the matter.
Both the parties.
This is respect between the
Another thing attention specifically taken is I had not been issued with the notice. And in my without notifying me, the improved order has been passed. My absence is noted in the improved order.
ಹೇಳಿದ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಅವ್ರಿಗೆ, ತೆಗಿತಾ ಇದೆ. ತೋರಿಸಿ ಅವರಿಗೆ. First you show it to Mr. Nitin, then we'll see. That will come to later if required. The contention of Mr. Nitin is he has not served with the notice. Let us first close this.
The property material number. That's available in March.
You take inspection properly and see it.
There are signatures found in the but I want to be
even they had to file a statement of objection indicating the said aspect, whether I was notified or not. That is the specific.
Acknowledgement of service, Syria. Do you have the acknowledgement?
I don't have exactly the things of Animana.
There are 4 of them. Have they been represented by counsel or?
No, nobody has been appeared. Not
ನೀವು ಸರ್ವ್ ಮಾಡಿದ್ರ ನೋಟಿಸ್ ಮಿಸ್ಟರ್ ಲೀಲಾಧರ್? Why do you want to get involved in that?
Give a date by tomorrow, Monday. I will give the entire art sheet and make the submission.
Whether services happened or not. If services happened, we'll look at the merits of it. If services not happened, we'll have to remand the matter.
I not the leeway. The permission, the correct address where you should say it. Because the address he has been permission. He could demolish. You want to do it a giant venture. Then they are considered illegal construction started. So that where exactly he is decided is the more important fact.
This address of 875, there are 1, 2, 3, 4 addresses are there. All 4 addresses are not correct.
Kumar is the petitioner.
Yes.
Including the existence of the petition.
Not existed to the petitioner.
Because he has made in the party. Then let him tell on what basis he has given the addresses before the joint committee.
There are several cases.
Mr. Lilladhar, if you are saying that they are not residing at this address and you have furnished the same address before the respondent, then they could never have been served and we'll have to accept the submission of Mr. Nitin.
Because 31 notice has been issued. He received it. He filed an application. Got stay order. The address furnishing that address also has been received. I furnished a copy of that magistrate.
So what is your contention? You're residing at these addresses.
Yes.
So produce some document to show this. If you're not residing at these addresses, then there's a problem. Learned counsel for the Shri N.R. Jagdishwar, learned counsel for respond number 1 to 3. Submit that he has received the original records. He'll examine and verify from them as to whether notice has been indeed served on the petitioners who claim that no such notice was served, and make his submission. Shri H.P. Liradhar, learned counsel for respond number 4, submit that the petitioners are not residing at the address shown in the cause title of the above petition. Shri Nitin, learned counsel for the petitioner, seeks for and is granted a week's time to produce necessary documents to show that the petitioner is residing at that address. Relist on 14 December. In the meanwhile, statement of objections to be filed. Yes. No, subject. 14, Mr. Naidu. None appears for the petitioner today also. The office objections have remained non-complied. List on 14th December. If by then compliance is not made, the petition will be liable to dismiss the proceeding. Affidavit, madam. Why you not received the affidavit? So we'll ask respond number 4 to come here. Are you going to file the affidavit by Monday or Tuesday, or we'll invite him here? Wednesday. If by then you don't file it, he'll be here. Despite the order date 31/10/23, affidavit has not been filed. 1 week's time is granted finally for the affidavit to be filed. If the affidavit is not filed by 13th, respond number 4 shall remain personally present before this court. We list on 13th. In the meanwhile, objections to be also filed to the main petition. Carry out the amendment, Paso. Carry out the amendment. Carry out the amendment. What is the objection? No. Objection on IA 1 of 23N, Mr. Yuram. Agidya, you received the copy. Your copy on Kodi or is ready. Objections hakidira ನೀವು ready? Ready ಅಲ್ಲ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನಕ್ಕೆ ಬೇಕು ನಾಳೆ ಹಾಕಿ ನಾಳೆ ರಜಾನ counsel for respond number 1 and 2 submit that the objections are ready and given 2 days time it will be filed. Relist on 13th December. Copy of IA 1 of 23 has been served on the counsel for the petitioner. As such, the office objection does not survive for consideration. Ramu, Mr. Kalyan is here always. ಯಾರೋ ಬರಲ್ಲ ಅಂದ್ರೆ ಅವ್ರಿಗೆ ಆಯ್ತು 13th. They're not been served with the report. There is no, what have we done after this? Notices have been issued. Inspection report has been filed by the counsel for respondent number 1. He submits that on the basis of the inspection, it is found that the ground floor of the building is now being used for commercial purposes, though the sanction was for residential purposes. And as such, notices have been issued. Necessary notices have been issued in that regard, which would be placed before this court within a period of within another 10 days time. Other less time ಕೊಡ್ತೀರಾ 10 days ಕೊಡ್ತೀರಾ 7 days. We just on 18th December. Who is appearing for the corporation?
I appear for respondent numbers 1 to 4, my lords, in serial number 19.
Yes, where the report?
19.1, there's another counsel, my lords.
Yes. Who is to file the
She's
report?
present
You
in the
are
court.
to file or
She has to file, my lords.
what happened to the report? Pass over, call that officer and find out why it's not come. The status of the application filed under subsection 8 of section 240. 4823, Mr. Sanjeev. Oh, officer passed away.
Only in respect of confirmation order 248.3, but the petitioner is going on construction. They take the direction.
You can't construct anything. File your affidavit and photographs, but you can't. We'll pass it now. You can't construct until your application is considered. You can't do anything. The BL Sanjeev Learned Counsel for respondent number 1 to 4 submits that the concerned officer has passed away. As such, he seeks for 2 weeks. That is a bereavement in the family of the officer who was to file the report. As such, he seeks for a short accommodation. Learned Counsel for respondent number 5 submits that the petitioner is going on with the construction despite the confirmatory order under subsection 3 of section 248. Once a confirmatory order is passed, the petitioner cannot proceed with any construction. If at all, as such, the petitioner is restrained from putting up any construction or carrying out any construction activities. If the petitioner were to continue, respondent number 1 to 4 are directed to ensure that no further construction or construction activities take place. Released on 13th December. What is the memo, Mr. Abhinav? Yes. Who are residing there.
reading it there, I'm visually impaired person. Therefore, I'm saying that it should be brought in central meeting here.
Registry has raised the objection contending that the prayers sought for are in the nature of public interest litigation. Shri Abhinav Raman and counsel for the petitioner has filed a memo stating that the petitioner is residing in the Gandhi Bazaar area, and as such, the works now being carried out by the corporation in that area, where the petitioner for implementation of FNL project
Pedestrianization and white topping.
for pedestrianization and white topping without following the requirements under the Rights of Persons with Disability Act 2016 and the applicable rules, is impinging on the rights of the petitioner. Accepting the said submission, office objection is overruled. Appear at the Pawan, who appears for Gandhi Bazaar matters? That AGA accepts notice for respond number 1, Directorate of Urban Land Transport, BMTC. 1 and 2, AGA. BL Sanjeev accepts notice for respond number 3 to 6. Hello, where is Mr. Sanjeev? Also for the petition, serve 2 sets of the petition along with annexures on the said council. BL Sanjeev to make a submission as to whether the designing of the pedestrianization and white topping project has taken into account the requirement of persons with disabilities. Persons with disabilities as contained under the Persons with Disabilities Act 2016 and the appropriate rules. Released on 13th December. Informing right away so that before they do more work and that needs to be removed, they can incorporate it immediately.
Also, even the presentations in March itself. Then, because of election, they said they cannot do anything.
It will become a waste of time and waste of money. It is also instructed. You ended up. You are Mr. Shiva Reddy. The KN Shiva Reddy has entered appearance for the petitioner. Hence, the memo of retirement filed by Mr. Sagar BB is accepted. He is discharged from the matter. Yes. Objections are filed, Mr. Layout is not approved.
Page number 16. Receipt for we have paid the litigation fee in terms of okay, this layout there is nearly 8 acres of land, 6 acres of land. It is the problem you also produce the photograph.
But where is the layout plans approval?
Layout is not approved, but unfortunately, year 15 also have come up with this. But 8 years, it was approved long.
But your construction is also not in accordance with the building bylaws. Even if we accept if we keep that aside, that layout is not approved, your construction is. So because layout is not approved, you can construct any which way.
as per page number 16 in our objection.
Yes.
We have paid the Kata.
ಆಯ್ತು. Payment ಮಾಡಿದೀರಾ? Just one moment, please. If you keep interrupting.
We have paid you. What the other submission is? The context with the another petition number 556. That is pretty constructed without the license.
Site measurement ಏನಿದು?
30.
ಇದು ಬರಲ್ಲ ಅದರಲ್ಲಿ. ಅದು ಬರೀ 500 square feet ಮಾತ್ರ ಬರುತ್ತೆ. Mr. Venkatesh, that 500 square feet matter is completely different. This 30 by 40 is 1200 square feet. The building bylaws would apply. If you construct like this, then it has to be demolished.
Before what is it? If I have to file a petition, within 60 days they have to give the permission. If they do not give the permission, 90 it is deemed permission.
ಆಯ್ತು. Deemed permission for what? ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ಪ್ರಕಾರ ಇರಬೇಕು. ಸೊ ಇವಾಗ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ಪ್ರಕಾರ ಇಲ್ಲ. Where is your report, Mr. Devraj? When was it filed? ಓ, ನೀವು ಅದು ಹೇಳಿಲ್ಲ. Report is only one letter. You filed the. Adaitu. But what is the building bylaws violation? Is it in accordance with building bylaws or not in accordance? ಅದೆಲ್ಲ ಹೇಳಿದೀರಾ? Plan sanction ಇಲ್ಲ ಅಂತ. Layout plan sanction is one. ಅದಿಲ್ಲ. ಇಲ್ಲಿ plan sanction ಇಲ್ಲ. But the construction, is it in accordance with the building bylaws? ಅದ್ ನೀವು ಹೇಳಿದ್ರಿ 4 ಸತಿ. ನಾವು 4 ಸತಿ ಕೇಳಿದ್ವಿ. ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ವೈಲೇಷನ್ ಇದೆಯಾ? ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಲ್ಲಿ ಸೆಟ್ ಬ್ಯಾಕ್ ವೈಲೇಷನ್ ಇದೆಯಾ? ಹೈಟ್ ವೈಲೇಷನ್ ಇದೆಯಾ? ಕವರೇಜ್ ವೈಲೇಷನ್ ಇದೆಯಾ? ಪ್ಯಾರಾ ನಂಬರ್
ಎರಡು ನಿಮಿಷಗಳ ಮಾಹಿತಿ ಆದ್ದರಿಂದ ನಿರ್ಮಾಣ ಮಾಡಿ ಕಳೆದಿರುತ್ತಾರೆ. ಯಾವುದೇ ವಾಸಯೋಗ್ಯ ಕಟ್ಟಡವನ್ನು ನಿರ್ಮಾಣ ಮಾಡಿರುವುದಿಲ್ಲ. ಹಾಗಾಗಿ ನಿರ್ಮಾಣ ಮಾಡಲು ಯಾವುದೇ ಅನುಮತಿ ಪತ್ರ ಪಡೆದಿರುವುದಿಲ್ಲ. ಅದೇ ರೀತಿ 4ನೇ ಪ್ರತಿವಾದಿಯನ್ನು 32 ಅರ್ಜಿ ಮಾಡಿ ಪರಿಶೀಲಿಸಲಾಗಿ ಎರಡು ಗೋಡೆಗಳನ್ನು ಮೊದಲ ಮಾಡಿಗೆ ಎರಡನೇ ಮಾಡಿಗೆ ನಾವು ಬೇಡಿಕೆ ಸಮಯದಲ್ಲಿ ನಮಗೆ ಕಟ್ಟಡ ಕಟ್ಟಡ ನಿರ್ಮಾಣ ಜಾಗವು ಖಾತೆ ಮಾಡಿ ನೋಡಲಾಗಿ ಪೂರ್ವ 1.5 ಜಾಗ ಯಾವುದೇ ಕಾಂಪೌಂಡ್ ನಿರ್ಮಾಣ ಆಗಿರಲಿಲ್ಲ. ಅದೇ ತೀರ್ಮಾನ ಮಾಡಿರ್ತಾರೆ.
Is it in violation of the building bylaws, Mr. Right? ಅದೆಲ್ಲೂ ಹೇಳಿಲ್ವಲ್ಲ ನೀವು. ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ನೀವು ಕೊಡೋದು, ಅವ್ರು ಕೊಡಲ್ಲ. ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿಲ್ಲ, ಅದು ಬೇರೆ. ಬಟ್ ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ಆಗಿದೆಯಾ? ಬಿಲ್ಡಿಂಗ್ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಕೊಟ್ಟಿಲ್ಲ, ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ವೈಲೇಷನ್ ಆಗಿದೆಯಾ ಅಂತ ಕೇಳ್ತಾ ಇರೋದು. ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ಆರ್ ಅಪ್ಲಿಕಬಲ್ ವೆದರ್ ಪ್ಲಾನ್ ಇಸ್ ಸ್ಯಾಂಕ್ಷನ್ ಆರ್ ನಾಟ್. ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗದೆ ಹೋದ್ರೆ ಆಗಲ್ಲ ಅಂತೀರ. ಅದು ಹೇಳ್ಬೇಕಪ್ಪ. ಯು ಹ್ಯಾವ್ ಟು ಸೇ ದಟ್. File a report as to what is that we'll deal with. That is a different issue. Irrespective of that, they can't violate the bylaws. Aspect of plan sanction at the 20th matter, otherwise we'll connect it and deal with it. But is it in accordance with the building bylaws or not? At least that they have to maintain, pending consideration of the larger matter. The larger matter that is listed on 20th, we'll connect it to that. But by then you will have to say whether there's a building bylaw violation. ಇಷ್ಟು ಜಾಗ ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ 1.5 ಅಡಿ. ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಬೈಲಾಸ್ ಪ್ರಕಾರ 1.5 ಅಡಿ ಇರ್ಬೇಕೋ 3 ಅಡಿ ಇರ್ಬೇಕು. ಅಲ್ಲಿ 1.5 ಅಡಿ ಇದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿದೆ. 3 ಅಡಿ ಇರ್ಬೇಕು ಅಂದ್ರೆ there's a violation. ಅದೇ ಹೇಳ್ಬೇಕು ನೀವು. Learned MS Devraj, learned counsel for respond number 2 and 3 by relying on
ಪ್ಲಾಸ್ಟಿಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಈಗ ಪ್ಲಾಸ್ಟಿಕ್ ಅಲ್ಲಿ
ನಿಲ್ಸಿ ಅದನ್ನ. ಡೋಂಟ್ ಡೂ ಎನಿ. ಏನ್ ಮಾಡಿದ್ರೆ ನಾವು ಡೆಮಾಲಿಷ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಯು ವಿಲ್ ಬಿ ಸ್ಪೆಂಡಿಂಗ್ ಯುವರ್ ಓನ್ ಮನಿ ಫಾರ್ ನಥಿಂಗ್. When there is a serious allegation made and it appears to be that you have violated the building bylaws also, don't carry on any construction. Setback violation ಆಗಿದೆ. ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಎಲ್ಲ ಡೆಮಾಲಿಷ್ ಆಗ್ಬೇಕಾಗತ್ತೆ ಆ ಸೆಟ್ ಬ್ಯಾಕ್ ಕರೆಕ್ಟ್ ಮಾಡಕ್ಕೆ. ಡೋಂಟ್ ಕ್ಯಾರಿ ಆನ್ ಎನಿ. ನಿಮ್ದೇ ದುಡ್ಡು ಹೋಗೋದು, ನಿಮ್ ಕ್ಲೈಂಟ್. ಡೋಂಟ್ ಡೂ ದಟ್. ಎನಿವೇ ವಿಲ್ ಪಾಸ್ ಇನ್ ಆರ್ಡರ್. ಕಾಂಪೌಂಡ್ ವಾಲ್ ಪರ್ಮಿಷನ್ ಬೇಡ ಅಂತ ನಮ್ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟೇ ಇದೆ. ಕಾಂಪೌಂಡ್ ವಾಲ್ ಬೇರೆ, ಇದು ಬೇರೆ. ಕಾಂಪೌಂಡ್ ವಾಲ್ ಇಸ್ ಡಿಫ್ರೆಂಟ್. ನಿಮ್ ಇಬ್ಬರದು ಬೋತ್ ಆಫ್ ಯು ಆರ್ ಇನ್ ಗ್ಲಾಸ್. Your layout plan sanction only is not there. Both of you are in the dock. Learned counsel for respond number 2 and Sri MS Devraj, learned counsel for respond number 2 and 3 by relying on the inspection report submits that the alleged layout in which the sites of the petitioner and respond number 4 are situated is unauthorized layout in as much as there is no plan sanction for layout formation which has been okayed, and the layout has been formed on the basis of a conversion order issued by the Deputy Commissioner without following the conditions imposed in the conversion order. On inquiry as to whether in the building being constructed by respond number 4 there is any violation of the building bylaws, he submits that since the layout itself is unauthorized, that aspect has not been examined. Respond number 1 and 2 is directed to 2 and 3 are directed to file a report as to whether the construction now being put up by respondent number 4 is in compliance with the building bylaws. If not, what are the deviations? Connect with so and so and relist on 20th. Okay? 20th.
With lordships kindly.
ಈ ಖಾತಾನ ಇನ್ನೊಂದು ಇದೆಲ್ಲ ಎರಡಿದೆಲ್ಲ ಒಂದು 600 ಆಯ್ತು ಇನ್ನೊಂದು ಈ ಖಾತಾ ಆಯ್ತು ಇನ್ನೊಂದು ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಬೈ ದಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ನಾಟ್ ಸ್ಯಾಂಕ್ಷನ್
ಅದು 20th.
connect with so and so on 20th.
Well, let's file a memo for retirement. That may kindly be allowed.
We have accepted and discharged you, Mr. Sagar.
Obliged.
Three.
For the respondents in this matter, my lords.
Hussain. Hello.
The last petition there.
Despite several adjournments have been granted to the petitioner to comply with the office objection, the same has not been complied with. Today also there is no appearance for the petitioner. It appears that the petitioner is not interested in prosecuting the matter. The petition is dismissed for non-prosecution. What is the office objection, Mr. Kumar? R4. You'll appear for the LRs? You'll appear for the LRs. You were appearing for respondent number 4 earlier, who is now expired. Will you appear for his LRs? Even you're ಕೇಳಬಹುದು ನಿಮಗೆ ಕೇಳಂಗಿಲ್ಲ. Naveed Ahmed seeks fund is granted 2 weeks time to ascertain if you would be notice order madbidana, Mr. Issue during the pendency of the matter, respond number 4.
All these problems do not arise.
Asking for restoration of the Kata.
The reason is not this could check. Restore the Kata back. Despite which the proceedings are also pending.
In person, the order passed by this court. 17-3. By that order?
The order of this court on a modification made is at page 36.
36.
On my application, which I did.
Who appears for respondent number 2?
My lord, I appear for respondents number 1 to 3, my lord.
Is the Kata not restored in person, the order passed by this court?
My lord, I've just filed my wakalat recently, my lord. I'll seek instructions, my lord.
There's already an order passed by this court. Now they have to come back for another writ petition for that. Why don't you file a contempt, Mr. They don't do anything without a contempt. Insofar as there are two aspects that you are saying. One is that the Kata has not been reverted as per the orders. That is contemptuous. So far as expeditious disposal, is there a direction for expeditious disposal? 12 weeks. Both are contemptuous. Writ petition is faster than contempt.
My lord, a week's time it can be granted, my lord. Whatever has to be done, I'll do the necessary, my lord.
Naveed Ahmed seeks for and is granted a week's time to obtain instruction whether you would be appearing for the legal heirs of respondent number 4 or not. Shri Mallikarjun Reddy seeks for and is granted a week's time to ascertain whether para 4 of the order dated 3/8/2023 has been implemented or not. Released on 14th December.
Obliged, my lord.
MLCP, you will have to take permission. But if an open site is being used for hiring out parking spaces in a residential area, government can use its own property. Correct. That is for the MLCP and traffic policy. That's what we are saying, that they can do. What is the policy? What is the policy of the BBMP? Do you permit private sites to be used for parking or no? If no, Andre, we will have to pass orders on that. If you say yes, then what are the terms and conditions? Yes. So that there's clarity of Learned Counsel for respondent number 1 and 2. While acknowledging service of receipt of the petition along with annexures, seeks for and is granted 10 days time to make a submission on para 4 of the order dated 6/11/23, released on 14th December at 2:30 p.m. Rate service, yes, 2:30 p.m. In office objection. Only a notice. 31. Yes. Five and 6 is a notice, Mr. Jacob. Section 5 of the Public Premises Act. Yes. Section 4 is, this is the section 4 notice. Public premises ಖಾಲಿ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಇನ್ನೇನು ಅಂತ ಹೇಳಬೇಕು. If you vacate by then, no action.
Well, someone there, dispose the petition. Provide opportunity.
Yes, we'll record this. There may be one word here or there not happily worded, but there's a show cause note.
The officers are after you dispose of the reason by that.
Threatened ಎಲ್ಲ ಮಾಡ್ತಾರೆ. The petitioner is before this court seeking for the following reliefs. The contention of Sri Jaikirti, MC Learned Counsel for the petitioner is that while Annexure G, the petitioners have been ordered to vacate from the premises within 15 days, failing which they will be forcibly evicted. Mahesh Learned Counsel appearing for the response submit that the notice and that Annexure G is a notice under Section 4 of the Karnataka Public Premise Eviction of Unauthorized Occupants Act 1974. And it is only in the event of the petitioner not vacating or not show causing sufficiently that further action will be taken in terms of Section 5 and 6 of the said Act. In that view of the matter, it would always be open for the petitioner to show cause by replying to the notice at Annexure G, dated 18/10/2023. Within a period of the Annexure G, dated 18/10/23. Time fixed under said notice is extended by a period of 15 days from today. And if the show cause is not satisfactory, liberty is reserved to respondent to initiate such action under Section 5 of the Public Premise Act. Needless to say, until then, the respondent shall not take any coercive steps against the petitioner to dispossess the petitioner of the said property. 27 same order, 28 same order. Annexure N. 26 Annexure G, 27 ali. J dated 28. 28. 27 Annexure J, 28 Annexure F. Yes. What are the officers? What is Annexure D, Mr. Moinuddin? Page number? 44. Who has issued this Annexure E? Who has issued Annexure E? You are only given a photocopy. Bari photocopy kotro, Xerox copy kotro. The counsel for the petitioner submit that Annexure E is the photocopy of the order passed by the PDO, and as such the original is not available with the petitioner. Accepting the said submission, the office objection is overruled, subject to any serious objection raised by the respondents. What are you seeking for? Take open just to your. For the respondents. The DG accepts notice for respondent number 1, 2, 3, 5, 9, 10, 9 and 10. Davangere, J. Anil Kumar accepts notice for respondent number 4, 6, 7, 8. Village accountant ನಿಮಗ್ ಬರ್ತಾರ ಅವ್ರಿಗೆ ಹೋಗ್ತಾರ ಪಂಚಾಯತ್ ಅಂತ ತೋರಿಸಿದ್ದಾರೆ ಸಂತೆಬೆನ್ನೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಂದ್ರೆ ಜೆ ಅನಿಲ್ ಕುಮಾರ್ ಫಾರ್ 9 AGA 9 ತೆಗೆದ್ಬಿಟ್ಟು issue notice to respond 11 and 12 returnable by emergency notice to respond number 11 and 12 returnable by 12th January. Yes. Yes.
I had given complaint against 11 and 12 and also legal notice now. Thereafter, my stop at this.
You are the owner of the shop?
Yes, sir.
What documents have you produced to show that you are the owner?
Yes, pending license has been issued in the key. So I'm paying the regular tax before the respondent.
This is 92
Yes, sir.
for 1 year.
It was renewed. Also, I felt
Where is the renewal? Where is the renewal as on today?
it is the tax credit.
License, first license stores. Yeah, I'm in the tax paid, one by one. Where the license, trade license. That is still 93. We are in 2023 now.
Thereafter, I am paying the regular tax. So the
Property tax is different. License is different. And the property tax, sir. Your
I may not do this. And this is Alex, page number 27.
27. Yes.
That's the second income. Under B1.
This is 2016. 23 Delhi that was.
You know, in respect of this one also, I have made a complaint. I paid,
You can address your arguments later. First, show us where is it that it's current 2023. This is 2016 is the last one that we are seeing. After that, we are not finding anything here unless you show it to us. Page. Yes. We'll come to your complaint, Mr. Counsel. You show us license antu illa. You have paid the license fee ant helidre. License fee is it current till 2023. ಈ ವರ್ಷಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
I have paid the entire taxes. For this, I have made the complaint. You have not issued the receipt. Okay. See, I made the complaint. Agree with notice in the Ram Panchayat. You have to solve the petition.
ಅದು ಹೇಳಿದ್ದೀರಾ, but you are not able to show us the document for that. 22, 23 or 21, 22 ಆದ್ರೂ ತೋರಿಸಿ that you have paid for. Last we see is 2016. ಅದಾದ್ಮೇಲೆ ಇಲ್ಲ ಇಲ್ಲಿ. 2017, 18, 19, 20 have you paid the license fee? Verify ಮಾಡಿ. Otherwise we can't grant you interim order. If they've collected it, yes.
I undertake to not conduct the business.
Seal open ಮಾಡಿ ಏನ್ ಮಾಡೋದು? Business ಮಾಡಲ್ಲ ಅಂದ್ಮೇಲೆ ಯೂಸ್ ಏನು? Counsel for the petition served. The notice to respond number 14 and 15. 11 and 12 is postponed for now. List on 15 December. Counsel for the petitioner served 2 sets of the petition along with annexures and learned AGA and Sri J.M. Anil Kumar. Submissions to be made by Sri J.M. Anil Kumar as to whether license fees have been collected from the petitioner for the year 22-23. Or consider mud will, and by the if you have it, you produce it. Then we'll have interim order, we'll have to hear. If you have paid till now, we can grant you an interim order. If you have not paid from 2015 interim order, barala. We'll have to hear and then decide. D and D. D page number ಏನು? And counsel for the petitioner seeks for and is granted 10 days time to file typed copy of annexure D and D. Yes. Kenneth. Not served. Okay. Pawan Kumar accepts notice for respondent number 1, 2, 3. The condition of the learned counsel for the petitioner is that without serving the provisional order, a confirmation order has been passed, in persons of which the building of the petitioner is sought to be demolished. The counsel for respondents is directed to secure the original records and make a submission as to whether the provisional order, show cause notice, and the confirmatory order has been served on the petitioner. List on 15. Needless to say, until then, no coercive steps to be taken against the petitioner. Srinivasa? The 25-9. Recall of recall lord. Srinivasa? A3 of 23 has been filed to recall the order. 25-9-23 to recall the dismissal order earlier passed. None appears for the petitioner today. If none were to appear for the petitioner on the next date of hearing, IA3 of 23 would also be liable to be dismissed. List on 15th December. During the pendency, yes, sir, notice 2. During the pendency of the above matter, respondent number 4 expired. Notices having been issued to the legal heirs of respondent number 4, namely respondent number 4 A to D. On 3 earlier occasions, the service could not be effected. As such, IA 6 of 23 has been filed to take out sub-service by way of paper publication. Accepting the reasons stated therein, the said application is allowed. The petitioner is permitted to take out sub-service by way of paper publication in the newspaper Kannada Prabha Bangalore edition. On or before. Isn't ಮಾಡ್ತೀವಿ for 20th December 23, showing the next date of hearing as 18th January. Carry out amendment. What is the dispensation for sir? What is this dispensation application? Urgency was in 2/2/22. ಅದಾದ್ಮೇಲೆ produce ಮಾಡಿಲ್ವಾ? So also submit that you would be entering appearance for the petitioner. ವಕಾಲತ್ನಾಮಾ ಫೈಲ್ ಆಗಿದೆಯಾ? By filing ವಕಾಲತ್ನಾಮಾ? ಯಾವಾಗ? Within a week from today, wakalatnama is filed. The registry is direct print his name as such. He seeks for and is granted 3 weeks time to obtain certified copy of Annexa E and produce the same. Relist on 18th January. Will anyway be subject to the civil suit. ವಕಾಲತ್ ಹಾಕಕ್ ಮುಂಚೆ ಡಿಸ್ಮಿಸಲ್ ಯಾಕೆ ಅಂತಾರೆ? Let him at least file his wakalatnama. What is this A and B, Rashik? You produced it or you still want dispensation?
Yeah, the copy of the notice was.
Accepting the reasons stated in support of IA 1 or 23, the production of the original of Annexa A and B is dispensed with by allowing IA 1 of 2023, subject to any serious objection raised by the respondents. Yes, what is this? Ready? Yes.
Instance of private respondent, they get that police and they have made me to sign and tell yours.
Police are party to this?
I'm not party. That is why I asked them to obtain a copy of the some alerts from the private respondent also. The case where the commissioner proceeds to pass an order without issuing notice, he modifies the earlier order without issuing the notice. On the strength of that notice, the municipality issues the withdrawal of my.
I challenge that and we'll make.
I will ask them to obtain that.
Serve a copy on the AGA. Counsel for the petition seeks for and is granted 2 weeks time to file amendment application to challenge the actions taken by the station house officer in obtaining, in prevailing upon the petitioner to sign a agreement. Petitioner and respond number 6 to sign a agreement. Yes, Mr. Dhananjay. 5.
Now already, then it's a road, that is concrete road. It's already there, and now already given to the village. It's already there and corporation is already given.
From your private land, you given. ನಿಮ್ಮ ಪ್ರೈವೇಟ್ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಇನ್ನ 10 ಫೀಟ್ ಬೇಕು ಅಂತ ಇದ್ದಾರೆ.
Road has to be formed in the eastern side and also in the western side. 12 meters of road has to be formed in the eastern side of my property and also in the western side. The western side are already road is 12 feet road. Eastern side of your road continues to not even when you go with reach at the cover. Your eastern side is the end of your money. That is minutes of what I have done. Eastern side of the western side of the road body can you the village charge for the if you open the road ಇಲ್ಲ ಅಂದ್ರೆ
ಅದು ಯಾವ್ದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ So adunu we'll have to take up along with this and dispose. ಎರಡು ಡಿಸ್ಪೋಸ್ ಆಗ್ಬೇಕಲ್ಲ. Connect the above matter with WP 3600 of 2023. ಇದರಲ್ಲಿ objections ಹಾಕಿದ್ದೀರಾ ನೀವು?
Yes, sir. I have made my objection. What they are doing now? Construction ಮಾಡಬೇಕು, building license ಮಾಡಬೇಕು. ಅವ್ರ road is 3 feet not ಮಾಡಬೇಕು. Already 10 feet road is.
ಅದು ಹೇಳಿದ್ರಿ ನೀವು. ಸೊ ಇವಾಗ ವೆಸ್ಟ್ ಅಲ್ಲೂ ಈಸ್ಟ್ ಅಲ್ಲೂ ಮಾಡ್ಬಿಟ್ರೆ ನಿಮ್ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ 30 ಅಡಿ ಹೋಗುತ್ತೆ. Mr. Bhandari, we'll require Mr. Bhandari's
And this submission is also not correct. That was not yesterday when police was entered. That would not be the activity.
Yes. Page number
66 point. What was the order passed? Initially, there was no issue related to road ownership. He has only reserved 13 cents of land for the purposes of road. And you see what was the order. Now, at their behest, the deputy commissioner proceeds to pass one more order, which is available at page 90. He 100 already dispute on that. That without issuing notice.
But where is this 13 guntas?
13 cents of land.
13 cents.
13 cents of land is reserved for the purpose of.
Where is the location?
This is the
West, east.
Second order. 13 cents ಅನ್ನ ರೋಡ್ ಮಾಡಿ ರೋಡ್ ಇದ್ದಿದ್ದನ್ನ ಈಗ ಇರೋ ರೋಡ್ ಅನ್ನೇ ಅವರು ಡಾಮರ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. That was the they were disputing that also. They were obstructing that public road also. That is why deputy commissioner proceeded to pass this order.
Madam, have you filed your objections?
And
we'll need your.
What they do, may request me not to page 90 for a minute.
But all of it is based on the deputy commissioner's order. They're not challenging it. Your stand on, because the location of this 13 cents seems to be an issue. Is it? Mr. Rajshekar says it's on the east. Dhananjay says it's on the west. ಇವಾಗ ಎಲ್ಲಿದೆಯಪ್ಪ 13 cents which adjacent ಅಂದ್ರೆ ಯಾವ ಕಡೆ ಈಸ್ಟ್ ವೆಸ್ಟ್ ನಾರ್ತ್ ಸೌತ್ that is not seen from this order.
They want to create confusion. That's why I am requesting my lord to take 90.
Yes.
What the deputy commissioner do on the basis of their representation, without even calling upon us to have over saying the matter, he proceeds to modify his earlier order. That is what is stated by the honorable court.
In the other matter.
Not as it may.
If you file your objection in that matter, all the clarity will come.
That's when I say
ಯಾರ ಮುಂದೆನೂ ಹೋಗುತ್ತೆ, ಎರಡೂನು ಒಟ್ಟಿಗೆ ಹೋಗುತ್ತೆ. Let us take both the matters. We need the deputy commissioner's report. Once their objections or report comes on record, the clarity will be there as to where in the confusion or otherwise that both of you are doing. We'll see. We'll see what it is. ನೀವು ಅವ್ರ ಮೇಲೆ ಹೇಳ್ತಾರೆ, ಅವ್ರು ನಿಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಾರೆ. ನೋಡೋಣ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಏನೇನು ಹೇಳ್ತಾರೆ ಅಂತ. 3,600 we are connecting to this. 3,600 of 2023 relist on 15th December. In the meanwhile, objections to be filed by the state as also by the relief agreement and the statement of objection clarifying the position. They would have passed this order after inspection only. They'll have to.
This is precisely what they are trying to do.
Let us see what their objection is. Then if they connect ಆಯ್ತು ಆಗೋಯ್ತು ನೋಡಿ. ಈ ಕೋರ್ಟ್ಗೆ ಬರುತ್ತೋ ಇನ್ನೊಂದು ಕೋರ್ಟ್ಗೆ ಹೋಗುತ್ತೋ ಗೊತ್ತಿಲ್ಲ. Whoever it goes to, if you have to hand over the file also, you make it clear to them that they have to make their statement. It may not be a statement of objection, it may be statement placing the facts on record with documents. The statement, though may not be a statement of objection, placing the correct facts along with accompanying documents. Let us see what comes from the. There must be documents and inspection report of the DC. Place that on. Not yet. Right. 15th. Interim order earlier granted is extended. 15th. Yes. What is this IA for permission? Delay. IA 1 of 23 has been filed seeking permission to file by respondent number 4, seeking permission to file the statement of objection of respondent number 4. It was filed belatedly, then the date fixed by this court. Accepting the reasons stated in IA 1 of 23, said application is allowed. The statement of objection filed by respondent number 4 is taken on record. Sheshadri? And appears for the petitioner. Released on 19th January. Rather, despite the order dated. Adinarayan. Yes. Okay, preemptory order has been passed. The counsel for the petitioner has finally appeared today. Yeah, it is, but again seeks for a short accommodation. Released on 16 January. If arguments are not advanced on that date, the petition will be liable to be dismissed for non-prosecution. Yes. You are filing your wakalatnama? Shri S.C. Shivramu, learned counsel, submits that he has now been instructed to appear in the matter. He seeks for and is granted 3 weeks time to go through the files and make his submission. Released on 16 January If arguments are not advanced on that date, petition will be liable to be dismissed. Now ready illa hoga. Pass over. Okay. Petition act. Shri MS Devraj seeks for and is granted a week's time to file his objection. On behalf of Shri Yogesh Naik, Learned Counsel for respondent number 4, 6, and 8, an adjournment is sought for stating that he is unwell. Relist on 18th. 18th? R3. Learned AG accepts notice for respondent number 3. Registry is right, printer name as such. You're lucky it's coming on 18th. That survey cannot come here. KLR go video. So Gurudat, that AG accepts notice for respondent number 1, Mandur, Bangalore East Taluk. BJ Somyaji accepts notice for respondent number 2. Counsel for the petitioner is direct furnished 2 sets of the petition along with connections. So Shodhan Babu. Okay. Yes. Yes. CMC Asan Yaru. Shri Ravi Shankar is directed to. He's not here. His name is not shown. Shri Ravi Shankar is directed to accept notice for respondent. Counsel for the petitioner to serve 2 sets of the petition along with annexures on the said counsel. The property tax challenge, bearing number so and so and so and so, at annexure A are stayed till the next date of hearing. Relist on 18th December. Yes. Again, what is wrong about it? Total ಏನಾಯ್ತು? Total ಏನಾಯ್ತು? Petitioner. Set aside ಆಗಿದೆ. So trial court ಅಲ್ಲಿ ನಿಮ್ಮ ಫೇವರ್ ಅಲ್ಲಿ ಆಗಿತ್ತು, ಹೈ ಕೋರ್ಟ್ ಅಲ್ಲಿ is gone against you. So against ಆದ್ಮೇಲೆ then stay ಇದೆಯಾ? Is that on record? ಎಲ್ಲಿದೆ ಅದು? It's not here. You have not produced it. Aniksha? One. Passed on 14/25/8/23. Although, did you bring it to notice? Was that placed on record? Okay, problem. This is 5A9. The order of 25/8 Act ಕೊಡ್ಲಿಲ್ಲ ಅವ್ರಿಗೆ. All orders are available on the website. You can just take a printout. You did not know about it. Malur? Shri Vijay Somyaji is directed to accept notice for respond number 1. Issue notice to respond number 2, returnable by 23rd January 2024. In view of the order of the Honorable Apex Court in SLP number 17947 of 2023, staying the operation of the judgment and order dated 14/7/23 in RSA number 2507 of 2007, which appears to be the basis for the impugned order dated 5/9/2023. The said order is stayed till the next date of hearing. Process fee and copies to be furnished by end of day tomorrow. Failing with the interim order, which can automatically vacate.
Act, please take the next step, there is an order of reassessment.
Page?
Page number 24. 3rd of February 2022, there is an order of reassessment. But please turn over to page 26, my lord. There's also a demand notice. So I accept this and I pay the taxes. I also file my lord at page 28. Revised return.
Yes.
But this stands for the period, my lord, 2016-17. Up to the date, my lord, the demand notice was given.
How do we know from it is, this says it is 22/23. Year of assessment is 22/23.
Yes, my lord. Please see, now what they do is, for the Lord annexure J, page 34. This notice is dated 16/11/2022. Lord served on me on 8/11/2023. Backdated, my lord. Now, my lord, for the year 2016-17, which is not beyond the period of 3 years, but they want to treat this as non-residential. They themselves, my lord, gave a revised order treating it as residential. Taxes are paid as per annexure D.
In 2021.
Yes, for an order of reassessment, there cannot be another order of reassessment. And my lord, order is given under the old act.
That old act, there's some, because they are, according to them, because they are reopening an assessment under the old act, filed under the old act, they are invoking 108, is what they are saying. It should be under the present section.
Reassessment order cannot be again reassessed.
There is another issue there. Under the old act, it is 3 years. Under the new act, it is 5 years. Mr. Satyanand has been asked to explain that. So you can't.
2016-17 is not, my lord.
Pawan Kumar accepts notice for respond number 1 and 2. The further proceedings pursuant to order dated 20/11/23 by respond number 2 at annexure K, demand notice dated 20/11/23 issued by respond number 2 at K1, show cause notice dated 16/11/22 at annexure J are hereby stayed till the next date of hearing. Counsel for respondent seeks for and is granted 4 weeks time to file their objections. Relist on 22nd January. And AGA accepts notice for respond number 1 and 2, 1, 2 and 3. The Manish Kumar for 4 and 5. In plan sanction, plan sanction, government connect with so and so and relist with so. Connect with so and so, date ಕೊಡ್ಬೇಕು. ಡೇಟ್ ಕೊಡ್ತಾ ಇಲ್ಲ, ಬರೀ ಕನೆಕ್ಟ್ ಎಲ್ಲ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಕೊಟ್ರೆ ಅದು. Where that list of Mr. Manish Kumar was to give us a list. ನಿಮ್ಮನ್ನ ಹಿಡ್ಕೊಂಡು ನೋಡ್ಲು give the list, so we'll sign the order. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗತ್ತಾ? You had sought for your declaration also. You had not made all the contesting. ಮತ್ತೆ ಹೋಯ್ತಲ್ಲಪ್ಪ ಬರಲ್ಲ. Once your relief, if your relief was only to say so and so is not elected, that is fine. But if we ask for your election, then we have dealt with it in a matter. Supreme Court has also dealt with it. On that ground only it will go. It goes and 7 rule 11 ಒಂದ್ರಲ್ಲಿ ಹೋಗಿದ್ರೆ ಮುಗೀತು. ಆಮೇಲೆ ಏನು ಉಳಿಯಲ್ಲ. The other allegations are not there. What is engaged? The petitioner is before this court seeking for the following learned Kanakpura MS Devraj for respond number 2 and 3. Learned AGA for respond number 4. Notice to respond number 1 is dispensed with in view of the proposed order to be passed. The petitioner is before this court seeking for the following reliefs. The proceedings in election petition number 6 of 2021 came to be dismissed by the senior civil judge and JMFC Kanakpura by order dated 1st September 2023 on the ground that all the candidates to an election were not arrayed as a party when the petitioner had sought for himself to be declared as the successful candidate. This court has dealt with the said issue in its judgment dated 26/7/23 in WP number 203232 of 2022, and has categorically held that where a declaration is sought for by the petitioner to be declared as the returning candidate in terms of subsection 1 of section 17, read with clause A of subsection 2 of section 15 of the Panchayati Raj Act, Raj and so and so Act, all the candidates were to be made a party. So the same has not been done. That is a defect which goes to the root of the matter, requiring the dismissal of the petition, which is what the trial court has done. In that view of the matter, this defect not being a curable defect, there would be no purpose served by considering the above matter as if the petition is dismissed at the admission stage itself. For limitation period is there. You can't, you lost your chance. I think. Tenant under the municipality. Yes. Because auction ಆಗಿದ್ಯಾ? You did not participate. It's a government property, you can't ask for it. We'll issue notice, let us see what they say. And AGA accepts notice for respond number 1 and 2. Tumkur Chiknaiknalli. TVF Kumbar is directed to accept notice for respond number 3. Counsel for the petitioner to serve 2 sets of the petition along with annexure and said counsel. Released on 14th December. 14th will Astral again Agala. 14th will try and fix a date for you to vacate. Yes. What is state? Pass over. Very adjournment act. New overall. Friday. Released on 47, released on 4th at 2:30 p.m. Auru barak easy again. Eber. Yeah. The soul warrior. Paso. Yaudrelli. Paso. In document. One document not then they require time. ಕೊಡ್ತಾ ಹೋದ್ರೆ ಹೆಂಗೆ ಇದು ಒಂದ್ಸತಿ ಎಲ್ಲ ಫೈಲ್ ಮಾಡಿದ್ರೆ And counsel for respond number 4 has filed a memo enclosing the copy of the appeal filed before the KT in Provisional Appeal number 481 of 2023. I will already note again. Counsel for the petitioner seeks for and is granted a week's time to go through the same and make a submission. Released on 15th December. Yes. Yes. Provisional order was not so. What does the KAT say about it?
KAT refers to some the corporation. What's that? The service.
Yeah.
Service brought was not established.
Get your file. The only issue in the present matter is as to whether BBMB cannot be a party to all that. In building bylaw violation, compromise, we can't, between private parties cannot help and BBMP cannot compromise. They cannot. So if it's in the present issue is as regard, the issue is only as regard whether it's been served or not. If they've been served, then this petition will go. There's a violation. We can't accept any violation once it comes before us. The only contention raised in the present matter is as to whether the provisional order under subsection 1 of section 321 of the Karnataka Municipal Corporation Act 1976 and the show cause notice under subsection 2 of section 321 had been served on the petitioner or not. The counsel for respondent number 1 and 2 seeks for and is granted 10 days time to secure the records indicating whether service has been effected on the petitioner. Relist on 15th December. Pass over. So Ramesh, ready? Aurilla ready and we'll pass over. Monday, it will go to January. Unless it's a serious urgency, we'll have it in the next 15 days. 53, the request to counsel for the petitioner relist on 23rd January. Yes. For appearing for R3, madam. R2 is Manjunath. You are appearing for R1 and R2. Okay. For R1, Manjunath for R2 antide. R2 yaru. R2 is the Chief Officer, Town Municipality, Vijaypura. Yaramma, Panel Council. Manjunatha? Manjunath antidalla. Manjunatha is correct. Yes, see. Registry is directed to Ms. Vidya S. has entered appearance for respondent number 3. Registry is direct delete the name of Shri Rakshit KN as that appearing for KVD respondent number 3. Registry is direct correct the appearance of respondent number 2 as Manjunatha AC. What is that? So, you filed your objections? You don't want to file. It's not necessary to file. If you want to argue, you can argue on that. But we need to get Mr. Manjunatha AC now. Manjunatha or petitions kottidira avarge petition copy. Released on 18th December. That in time hoga. The counsel for respondent number 3A to D seeks for and is granted 3 weeks time to file a statement of objection. Nimdo? Nobody has filed. Similarly, the submission made by learned AGA. 4 weeks time is finally granted to file objection, which shall be filed on or before 12th January, failing which it will be taken as not filed. Relist on 22nd January. Interim order earlier granted is extended till next. Yes.
I'm the upgrade owner of the second property. It is undisputed fact that without following any due procedure established in the law, courts will immediately they have taken the decision. In these circumstances, this court, lecture section, page number 47.
You are supposed to make your submission as to on what basis condition number 15 and 21. R1 arrow. Yes, madam. On what basis was condition 15 and 21 imposed? Page 12.
Well, highly refer page number 32. Highly refer page number 32. Order number 2011. It was filed in the year 2011.
Yes.
Respondent is also party to this suit. They able to conclude that there is already a drainage. Page number 41. If the defendant intends to construct the drainage, he is at liberty to construct as per the procedure of established procedure.
Yes.
Second point.
That is what she is asking for. Trial court alone. Trial court Yav municipal corporation doesn't appear. All judgments passed in the trial court against the municipal corporation are without appearance of a counsel, or even after appearance, no written statement is filed. Even if a written statement is filed, no evidence is led. That is what has happened in your matter also. No evidence has been led. So let them place on record whether there is a drain situated in that location. And if there was a drain, and if they are doing a box drain in that location, then there is no problem. But if there is no drain and they are doing a new drain, then they have to acquire. If there is a drain, 194(2) is enter upon and construct in the new drain in the place of an existing drain. See, there has to be an existing drain. If there is no existing drain, you cannot form a new drain without acquiring. Submission of learned counsel for respondent number 1 is that it is by exercising powers under subsection 2 of section 194, that a new drain is sought to be formed where there was an existing drain. She seeks for and is granted 10 days time to place on record documents indicating the location of the existing drain. Otherwise, you can't do anything. If there's no existing drain, you could not have done this. Existing drain. Relist on Learned AG also seeks for and is granted 10 days time to make a submission on condition number 5, 15 and 21 of Annexure A. Relist on 18th December.
I'm appearing for the respondent R1 and 2. Kindly pass over the matter, my lordship.
So, Pardalkar. Listelli. Ground rent. Learned counsel for respond, none appears for the petition. Learned counsel for respond number 1 to 3 seeks for and is granted 4 weeks time to file his statement of objections. If objections are not filed by 12th, it will be taken as not filed, relist on 18th January.
The first petition is concerned law.
Hmm.
And this petition is seeking for a mandamus. When you already eventually have taken a necessary action, again the respondent number 4, they approach the tribunal that
So,
they file the writ petition that my writ petition becomes
infractions. 59. Learned counsel for the petitioner is before this court seeking for the following reliefs. During the pendency of the above matter, notices have been issued by the corporation to respond number 4. A provisional order had been passed and notice issued to respond number 4 under subsection 1 and 2 of section 321, followed by a confirmatory order under section 3 of section 321, which was challenged before the Karnataka Appellate Tribunal in WP in appeal number 1257 of 2017, challenging with WP 12952 of 2020 has been filed. In that view of the matter, above petition has been rendered infructuous and is dismissed as such. 59. 59.1. Yes, Mr. Anmantrayappa. Yen ground ಏನಪ್ಪ ಗ್ರೌಂಡ್ ಏನಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್. ಏನ್ ಗ್ರೌಂಡ್ ಹೇಳಿ.
Copy of the confirmation order was passed.
KT ಏನ್ ಹೇಳುತ್ತೆ ಸರ್ವಿಸ್ ಬಗ್ಗೆ?
says that there are no valid grounds to set aside the confirmation order.
Yes. Confirmation order ಆಯ್ತು. 21/7/2017 during 7 days time. 24/7. 1/8 ಅಲ್ಲಿ confirmatory order has been passed. 7 days. 7 days has been given. ಹೇಳಿದ್ರಿ ಬಟ್ ಅದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ಲ. (21/7) notice was served on you on 24/7. ಯಾವುದು 24/7 ಅಂತ ಬರ್ದಿದಾರಲ್ಲ 24/7. ಇದು 24/7 ನಿಮಗೆ ಸರ್ವ್ ಆಗಿಲ್ಲ ಅಂತೀರಾ? ಸರ್ವ್ಡ್ ಆನ್ ಅಂತಿದೆ.
What is the extent of violation was not disclosed? Records produced with DB, but what is the extent of violation? And
Was it served, Mr. Pawan Kumar? Was that notice served? Provisional order. It says 24/7. (32). Backside of page 3 is signed and received that you are raising a new order contention. Before the KAT, you said that the confirmatory order has not been received. You had admitted receipt of the provisional order. Now you are saying provisional order has not been received. There's a clear finding that it was served on you on 24/7 2000. What are your, where is your appeal before the KAT? What ground number? The construction prior to 2013. If it is prior to 2013, we'll have to wait for the Supreme Court order. Post 2013, we'll deal with that. Prior to 2013, we don't know if the Apex Court is going to uphold your akrama sakrama. Then they'll have some benefit there. We don't want to touch properties prior to 2013. Yeah, we can't put it back there. If we put quashes it, then we can demolish. Otherwise, no. The building in question is one which has been constructed prior to 2013. Even if there may be any violation, the petitioner would be entitled for the benefit of the Akrama Sakrama scheme, depending on the decision of the Honorable Apex Court. In that view of the matter, the present writ petition is adjourned sine die, liberty being reserved to the petitioner and respondent to move the matter after the judgment of the Honorable Apex Court. Needless to say, until then, the corporation not to take any coercive steps against the petitioner. You have to place it on record that this is the situation. Then if we demolish, it's very easy to order demolition. But if tomorrow the order is otherwise, then they will suffer irretrievably. You can't put back that building. And that will remain on the conscience of this court. We can't do that. You move that matter, whatever happens in that will be binding on people. 2013 and later, we will take up. But wherever Sakrama and Akrama is may be applicable, we'll, for now we are on caution. Madi, same order. Construction is prior to 2013. Yes, in it. With liberty being reserved. Sandesh, despite the order dated 3/11/2023. Today also there is no appearance on part of the petitioner. It appears that the petitioner is not interested. Raghunath. Pastor. Yes, for Mr. Putegoda. Ready? Pastor. Allotment of? Huh. $51. Yes. Auction ಆಗಬೇಕಾಗಿತ್ತು. You buried 2 paras ಇದೆ. 53 is your notice. Where are these shops located, Mr. Janardan? Where are these located? Where are these shops located? Tannery Road. ಏನಾಯ್ತು? Huh? Page? Page? ಇಲ್ಲ 1412. 1412. Yes, 1412. Any shop being vacant in which petitioner can be accommodated. So now the demolition has not happened. ಹನ್ನೊಂದು ವರ್ಷದಿಂದ ಡೆಮಾಲಿಷನ್ ಅಂದೇ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂದ್ರೆ ಏನಿದು? ಒಂದ್ ನಿಮಿಷ. 26? When was it filed? 35/20. Again, what have you done? Have you demolished it? That is what you have been saying for last 11 years. ಇದು ಆರ್ಡರ್ ಆಗಿದ್ದು ಯಾವತ್ತು? Writ petition of 2012, order of 20th March 2013. Ten 12. there any photographs? Either photographs either though. Along with your DPR, detailed project report, the photographs of this property. Well, then this building is looking very dangerous.
Objection on 10/12/2021.
10/12/21 is the affidavit that they have filed. That will you filed. Copy of the notes, sir. Yes. Yes. 26/11. One minute. Memo with detailed project report. It is in such a dilapidated condition. Who will be responsible for it, Mr. Janardhan? Who will be responsible if something happens there? If we see this photographs, part of the building, the roof is caved in. Yes, they did, but now when we look at these photographs as they exist today, the roof has caved in so many places. This doesn't look like it is repairable. It's all empty, and if somebody were to be there and it caves in, you may want to take the risk for yourself, or your client wants to take a risk for himself, but there'll be other customers who will come there. This may not be. We'll appoint somebody to do a study on this building and submit the report. They undertake a lot of things, but we'll have to be careful on allowing.
Whether it is available or not, that is the issue. They can't get away by making some statement.
But these photographs speak for themselves.
That's why they said, before this court goes, that he said, say to the fact that
the issue in the present matter is as to whether we'll direct that. Is as to whether the market building in Tannery Road near Doddi is in a dilapidated condition or habitable condition. And even if in dilapidated condition, whether it is repairable so as to be brought up for auction where the petitioner could participate. In that view of the matter, who is the person who can do it? Madam AG, dilapidated condition PWD alle ಮಾಡ್ತಾರಾ? Dilapidated building, PWD can carry out an inspection, submit a report. The BBMP has themselves said they don't have people. In Andhra, the report was very good. ಯಾರು ಫೈರ್ ಅಂಡ್ ಎಮರ್ಜೆನ್ಸಿ ಯಾರು ಹೇಳಿ ಅದು ಮಧ್ಯಾಹ್ನ ಹೇಳಿ ವಿಲ್ ಪಾಸ್
First place, he has no such vested right. He has no such vested right.
Mr. Neglur, there was an order passed by this court on 20th March 2013, bringing up for auction.
Yes.
Have you conducted an auction thereafter? Then what have you been doing with the order passed by this court?
Auction order can be done.
Then why did you undertake? Why did you undertake before this court? You undertook before this court that you would carry out the repairs and expeditiously and bring up the property for auction. That's undertaking given by you, which is recorded by this court. This was in 2013. Repair, construction Allah. So why did you make an undertaking before this court without, on what basis? Who was the person who gave the undertaking? Have you taken action against that person? So your BBMP officers can come to this court, give some undertaking and get away with it. Then it appears to be so. After repairing the same and bringing it to habitable condition, the respondent would auction the said shops. He is the undertaking given in 2013. When was that report received? There's no date for that report also. Date is blank. Say no signature. We are directing the PWD to conduct an inspection because there's no meaning to the undertaking given by your officers in this. But do they have the wherewithal and technical expertise? Dilapidation, repairability, and who is carrying on business is simple. Repair. So and so is appointed to carry out an inspection. So and so is appointed to carry out an inspection of the market of the market building in Tannery Road near Doddi and make the submission as under 1. The nature and condition of the building, whether it is in whether it can be said to be in dilapidated condition. 2. The nature and condition of the building, whether it is dangerous for human habitation as it is. 3. Whether, if in dilapidated conditions, can it be repaired? If so, what are the repairs to be conducted in the time frame? 4. Are there any existing businesses being carried out in the said building? How can there be, if you are saying dilapidated, how can there be existing businesses? What have you done against them? You're not bringing up the property for auction. It's a public property, public money. For the last 12 years, you have not done anything. How much money has been lost for the government, for the public exchequer? Who will pay it? Correct and mele. So who are the people responsible for this? You have to take action and recover that money from them. Repair madala, auction go tarala. It's not whether the petitioner succeeds or not. It is 20 shops which no revenue has been earned for the BBMP. And BBMP says you don't have money to repair the roads and potholes. You know, money yen martira. That is why when a responsible person is given an undertaking, at least that should be complied with. After recording in by this court in 2013, very sad state of affairs. Whether any shops are, whether any businesses are being conducted in the said shopping complex, if so, by whom and what business? The inspection to be conducted commencing from 10:30 a.m. on 8th December. Report to be submitted by 13th December. Agala, technical, they'll take some time. Report to be submitted by 11th January, released on 18th January. An affidavit of the Chief Commissioner to be filed. If the report indicates that the building is in dilapidated condition and unfit for human habitation, the affidavit of the Chief Commissioner to be filed as to how in such a dilapidated condition businesses are being allowed to be operated. More so, even if the business operator is willing to undertake the risk, how the citizens are being allowed to being put at risk by entering the premises which are dilapidated in nature. Released on 18th September. Copy of the report to be filed by so and so after furnishing to the counsel for the petitioner and respond number 1 and 2. The registry director prints the name of the learned AG in the cost list so as to enable compliance with the above orders. Commencing from 10:30 a.m. on 8th. It is clarified that if further inspection are to be conducted at other times, the same could be conducted by so and so Mele at the time convenient to them. No. Yes. 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 Yes.
21, 22, 21, 23.
Yes.
They have appreciated my work. Now what the corporation is the municipality customer and they say I have put up extra work. Demolition.
15.3 they praise you and 17.3 they issue this.
It says I only informed that I have put up 2 room sections. So as I accommodate the quarantine patients.
I think your quarantine ಬೇಕಾಗಿಲ್ಲಲ್ಲ.
Now it is second methods either I have to demo it, I have
So will you remove it or they have to remove it?
the services rendered by me. Let them at least consider to regularize it, so that it will be helpful for the
Is it regularizable?
extra rooms, quarantine rooms. Quarantine rooms.
ಇವಾಗ ರೆಗ್ಯುಲರೈಸ್ ಮಾಡಕ್ ಆಗತ್ತಾ? Is it part of the is it within the height of the building? Have you made an application for regularization?
Who brought it to their notice?
Next N.
Next N 2020 was on 17th May 2021. Application is on 25 May 2020.
So you have to consider Annexa N. Verify and if N can be considered, the counsel for respond number 2 seeks fund is granted 2 weeks time to ascertain if Annexa N representation can be considered in accordance with law. Released on 18th December. Interim order earlier granted is extended till next date. Pass over. Pass over and the order dated and the So ಯಾವಾಗ demolition? ಇನ್ನ ಮಾಡಿಲ್ಲಲ್ಲ. So give us a time frame in which you will do that. You have to give us. You're demolished. Verify if they have demolished, then nothing will survive. Pass over. Verify.
My lord, I appear in serial number 67, my lord.
67, pass over, Mr. Reddy.
Please.
Also check with your officers if respond number 3 has demolished, because they are saying that they've already demolished the deviated portion.
Please.
Verify Madi Heli. We have passed it.
Please, my lord.
Yes. Council.
The drainage water comes to the land of the petitions. Petition we have given any representation respondents to.
ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಬಂದಿದೆ ಅಂತ ವಿಲ್ ಗಿವ್ ದೆಮ್ ಎ ವೀಕ್ಸ್ ಟೈಮ್. If drainage water is coming, you need to immediately take action. ಅವರೇ ಅಲ್ಲ ಬಾಕಿ ಜನಕ್ಕೂ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ. The counsel for respond number 1 seeks for and is granted a week's time to obtain instructions and make a submissions. If in writing by filing a statement of objection, which shall be so done on or before 12th December, released on 14th December. Yes. $69, huh? You're ready, Alva. Pass over. Yes.
My lord, in serial number 70, I appear for the respondents number 2 to 4, my lord.
70 has been adjourned, Mr. Reddy.
Obliged, my lord.
Inform ಮಾಡ್ಲಿಲ್ವಾ? ನಾವು ಕೇಳಿದಾಗ ಮಾಡಿದೀವಿ ಅಂತಾರೆ.
Very well.
70, when the matter was not called out in seriatim, Shri K.S. Mallikarjun Reddy for respond number 2 to 4 inquired about the same and submitted that he was not informed about the mentioning made in the morning. Yes.
Obliged.
You are also not informed. Similarly, the submission made by counsel for respond number 1. Yes, 71.
As I appear for the respondent.
The tax is exempted. What they say, 25% of the tax as a service from demanded.
25% of the tax as service charge. What is this 25% service tax? Service charge on that? 7A1 of ತೆರಿಗೆ ನಿಯಮ 7A1. ಯಾವ 7A1 ಇದು? Page?
He's on the rules.
Property tax. Which are providing civil entities can be levied in respect of building exempted from property. Rate of 26% of property tax given from such time generally, but for example, even though the entire 30-acre land is not children compound everything is provided by the son. Given that there is also called as a tax, you know, from the most of
It will 3-7.
7A. Here service charge for the building exempted from property tax. Service charge for providing civil entities that be levied in respect of building exempted from property tax under
Civic communities ಅಲ್ಲ civil amenities ಅಂತಿದೆ.
One compound may not the extent of 30 acres of land.
Civil amenities ಅಂದ್ರೆ ಏನು? What is the definition of civil amenities? Is it been
Sanction plan and not by the mood of it.
Has civil amenities been defined? What is civil amenity? Mr. Ajay.
Yes, my lords.
When we get back after lunch, you'll have to tell us what is the civil amenity?
Yes, my lords.
Rule 7A.
My lords, it's discussed in a judgment. I've produced it along my statement of objections. There's a judgment. My lords were to come to page 29 of my statement of objections. My lord, the judgment is there. My lords, afternoon I'll assist, my lords. I'll be there personally. I'll assist.
It's already been produced at 29. I mean.
Well, judgment, yes, the judgment is produced. In fact, there is a judgment which my learned friend is relying on, my lords. He's relying on the judgment.
Get back in the afternoon.
Yes, my lords.
Yes. You informed everybody. In the written consent, learned counsel for the petitioner seeks for and is granted 3 weeks time to get ready and address his arguments. Finished on 23rd January. 70? If you don't tell us by then, we'll dismiss your petition. You already adjourned it 3 times for that. 73. Learned counsel for the petitioner seeks for and is granted 2 weeks time finally to make a submission as to whether the petitioner would make payment of the amounts or would carry out the works or would make payment of the amounts for respondent number 4 to carry out the works. Relist on 14th December. It is made clear that if submission is not made on that date in regard to this, the petition would be dismissed for non-prosecution. Wait, buddy. Yes. You're not informed. Date is fixed. Date is fixed. Dates are fixed in all matters. List number 2, CL number 3. Inform ಮಾಡಿದಿರಾ? Going to inform ಅಲ್ಲ, inform ಮಾಡಿದ್ಮೇಲೆ ಬನ್ನಿ. Will ಬೇಡ. Continuation ಬೇಡ. Okay, pass over. 98. Huh. Thank you. And counsel for respondent number 1 to 3 has filed a statement of objection, but ours submits that there is some discrepancy in the measurement of the property. In that view of the matter, respondent number 1 to 3 are permitted to carry out an inspection of the property and as also measurement of the property and submit a report. The inspection the boundaries ilva identification heng ಮಾಡ್ತೀರಾ the petitioner shall identify the property at the time of measurement, which shall be cross-verified by respondent number 1 to 3 from the available records. The inspection measurement to be carried out commencing from 10:30 a.m. on 21st December 2023. Report to be by 9th December 2023. Report to be submitted by 14th, released on 19th. Yes. Yeah, report. Also raised a judicial committee. Mr. Busre.
Please, my lord.
My
lord, tender has been called and work order has been issued. I have filed documents along with memo, my lord. On 29th morning, I have filed a memo, my lord.
That counsel for respond number 1, 3 and 4 has filed a memo dated 29/11/2023, enclosing therewith the
work orders.
Work order dated 26/10/2023. ಎಲ್ಲ ಕವರ್ ಆಗುತ್ತಾ ಇದರಲ್ಲಿ?
ಎಸ್ ಮೈ ಲಾರ್ಡ್, ಎಲ್ಲ ಕವರ್ ಆಗುತ್ತೆ ಮೈ ಲಾರ್ಡ್. ಇದರಲ್ಲಿ ಜಾಮರ್ಸ್ ಇದೆ, ancillary security services,
The said work orders relate to provision of CCTV, jammers, and other security services, including body-worn cameras for the invigilators, and all exams to be conducted by the Karnataka Public Service Commission. The submission is that within the time frame prescribed in the contract, these equipment would be supplied and installed at all centers where KPSC conducts its examination. This submission is taken on record. Nothing further remains to be ordered. As such, the petition stands closed.
Much obliged.
The petition is allowed. A certiorari is issued. Notice bearing so and so date 14/9/23. Issued by respondent number 1 is hereby quashed. Proceedings pending before BBMP on the basis of the complaint dated 25/8/23 while Annexure C is hereby quashed. The petition shall be bound by any order passed in OS number 781 of 2023, and any transaction will be subject to the principles of lispendence as contained in section 52 of the Transfer Property Act. The petitioner, if were to continue with the construction, will not be entitled to claim any equities if adverse orders are passed against the petitioner in the civil suit.
Obliged. Great.
First what? And appears for the petitioner, though called twice, once in the forenoon session, one is in the second time in the afternoon session. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. The Suresh. You furnished the petition. ಪಂಚಾಯತ್ ಅವ್ರು ಯಾರು ಬರಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? ತಾಲೂಕ್ ಮುನ್ಸಿಪಾಲಿಟಿ ಆನೇಕಲ್ ತಾಲೂಕು. You can't spread the red carpet for them to come. You can't put a red carpet for them to come. We'll have to adjourn. Petitioner has to wait for them to come. It's not acceptable. ಬಂದ್ಬಿಟ್ಟು ನೀವು ಕೌನ್ಸಿಲ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? We are adjourning for that reason. Matters get piled up. That is part of your CCMS. Even the advocate will have. None appears for respond number 2. The affidavit has also not been filed as directed on 3/11/23. If none were to appear for respond number 2, on the next date of hearing, the bailable warrant would have to be issued to respond number 2. Released on 14th December. Under the caption for issuance of bailable. Although 16. Counsel for the petitioner has carried out the amendment and filed amended petition. Objections? You filed or you will?
Yeah, fine.
Counsel for respond number 2 seeks for and is granted 3 weeks time to file a statement of objection. Objections, if any, by 12th January, released on 22nd January. Yes, madam. Who is appearing for respond number 1 to 4? (19.1) you are appearing. All that you have to do before, not here, when the matter is called. What are the setbacks to be left? What is the setback, and has the setback been left? Your officer has not followed the directions which have been issued. It's not the way to carry out measurement. We did not ask him to give the dimensions of the property. We asked him to measure the property to verify if the construction is in accordance with the building bylaws. I furnished copies to both of them. Inspection report has been filed. Copies thereof have been furnished to the other councils. The inspection report is not in accordance with the directions issued by this court on 12/10/2023. Relist on 15th December. Who has carried out this inspection? The fourth respondent. shall remain personally present before this court on that date. ಬೆಳಗ್ಗೆ ಈ ಕಡೆ ಇದ್ರು ನೀವಿರ್ಲಿಲ್ಲ, ಇವಾಗ ನೀವಿದ್ದೀರಾ, ಅವರಿಲ್ಲ.
I don't think that is not
Just a moment. First, we have to get them. Mr. Devraju. Hello, sir. Aso. The 2016 matter, Mr. Counsel. We are not going to give you a time when you want it. 2015-16. ಇದು dated matter ಇದು. ಮತ್ತೆ ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಇದು? 5 ನಿಮಿಷ ಆರ್ಗ್ಯುಮೆಂಟ್. ನೀವು ಇದು ಹೇಳಕ್ ಬದಲು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಎಷ್ಟು ಟೈಮ್ ತಗೊಂಡು ಅದು ಮುಗಿಸ್ಕೊಂಡು ಬನ್ನಿ. ಅಸೋ Mish Patil. None appears today also. Though called twice, once in the forenoon session and once in the afternoon session. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed. Raghunath. None appears, sir. Smith Deshpande, I think they said there's some bereavement yesterday. So Raghunath, none appears for the petitioner, though called twice. In the interest of justice, relist on 20th December 2023. If none were to appear for the petitioner on that date, the petition would be dismissed for non-prosecution. You are a contesting party, Mr. Deshpande? C2. You have to file your objections? Yes. Puttegoda. ಹೇಳಿದ್ರು ಅವ್ರಿಗೆ ಬರಕ್ಕೆ ಪುಟ್ಟೇಗೌಡ ಕಾಂಟ್ಯಾಕ್ಟ್ ಸಿಗಿಲ್ಲ ಅಂದ್ರೆ None appears for respond number 2 and 3, though called twice. In the interest of justice, relist on 20th December 23. If none were to appear for respond on that date, matter would be taken up for consideration the submission made by the counsel for the petition. Yes, demolition has happened. He says he has demolished.
My lord, serial number 67, my lord.
Yes.
My lord, the demolition. My lord, the demolition is in progress. It is happening at the moment.
It's in progress. He is still demolishing. He will demolish everything. When will it be completed? ಎಷ್ಟು ದಿನ ಆಗತ್ತಪ್ಪ? 3 weeks. Mallikarjun Reddy case has entered appearance for respondent number 1 and 2. Delete the name of Shri V. Srinidhi as that appearing for respondent number 1 and 2. Shri Varun J. Patil has entered appearance for respondent number 3. Delete the name of Shri Prashant VY as that appearing for Kvator respondent number 3. Shri Varun J. Patil submits that the demolition is under progress and given 3 weeks time, the same would be completed. Shri Mallikarjun Reddy, the counsel for respondent number 1 and 2 confirms that the demolition is under progress. Released on 25th January, once the demolition is completed, the respondent number 3 to inform respondent number 1 and 2 of such completion, to enable respondent number 1 and 2 to cause another inspection to verify if after demolition the existing the standing structure complies with the building bylaws and sanction plan.
Obliged, my lord.
Yes.
The control for petition is accomplished because the DPFT has taken action.
Demolition against your officer have to take preventive measures. Section 8 of 240 is clear. It's a waste of national resources causing this demolition.
Building was under construction. Now it is constructed and already in the subsidy. There in application. Only the grades of only the subjects, then only windows will open.
Your inspection report has been filed. It's up to you to bring it in, like Mr. Varun Patil said, he will demolish and bring it in accordance. You choose that option, you demolish and bring it in, or they will come and demolish. Our bandre Sinchana or nobody else. Our officers bandre kashta.
Everything on the 15 of the take up there. That was this whole problem. At that time, the council said that
He is wanting to withdraw this, but we are giving you one option. He is withdrawing it because they are passed a demolition order.
Instead of 4 feet, 1 feet, 3 feet left, setback also. 1 feet as per the sanction, but 1 feet irregularity, that is the allegations. Okay, literally a neighboring property.
Ready. There is no objection to be filed. You have to challenge that order. We can't advise you. We can't go behind. There a decree pass ಮಾಡಿದ್ದಾರೆ corporation. But if you want to demolish it, we'll record it and give you some time. Learned counsel for the petitioner submit that he wishes to withdraw the above petition, accepting his petitioner is before this court seeking for the following reliefs. Learned counsel for respondent number 2 and 3 submits that subsequent to the confirmatory order under subsection 3 of section 248, the demolition order under section 356 has been issued. In that view of the matter, learned counsel for the petitioner seeks permission to withdraw the above petition, accepting his submission. Petition is dismissed as withdrawn.
My lord, serial number 75.
69, madam. 71. You always have the liberty. 71, yes. Take it.
My lord, 56.
56. 56 dismissed. 71, where is Mr. Egde? Password. Complied. Office objection, the counsel for the petitioner submit that the office objection have been complied. They are respond. Brenna. K. Krishna is directed to accept notice for respondent. Counsel for the petitioner to furnish 2 sets of the petition along with annexures. The counsel for respondent is granted 4 weeks time to obtain instruction, make a submission, released on 18th January. So, yes. Same order. Petitioner is before this court seeking for the following reliefs. Both the counsel submit that the list in the present matter, a similar list as that in the present matter, has been decided by a coordinate bench of this court, while it's ordered 17 January 2023 in WP 24580 of 2021 and other connected matters. In that view of the matter, I pass the following order. Petition is allowed in part. Respondents are restrained from interfering with the property of the petitioner. Liberty is however reserved to the respondents to initiate acquisition proceedings in terms of the right to fair compensation so Act 2013.
Safeguard possessory rights because all the properties are commercial property. It are meant to.
Once we are restraining them from interfering with their position.
They are not interfering. But when we went there for extension of trade license, we not they say that petition I can only they are saying all these things.
Needless to observe that a citizen is entitled to gift the property to the state. You gift kotre togoli voluntarily. Otherwise, acquire ಮಾಡಿ. Needless to say that until such acquisition is complete, the petitioner would be the owner and be entitled to exercise all ownership and possessive rights in respect to the property. You can't get into it.
Recently, in fact, a number of my works, payments were not made. Of course, we are not. Unfortunately,
this will be correct. That is
Yes. You are not implemented CCMS at implemented. But then in the order copy barbekala, you should. The submission made by Mr. Ramesh on the last occasion is because certified copy is not required. Why do you require certified copy? Certified copy is old story. Letter is also not required. Once you are in CCMS, all the judgments which are passed by this court are immediately received by you on CCMS without application. So once you receive it, what is the delay in processing it? What are you waiting for after receipt in CCMS? Similarly, the order was passed on 27 September. And you were required to process within 2 weeks, determine the balance and pay in 2 weeks thereafter. Just 1 moment, madam. 2 weeks processing andre, even if you have got it on 30th September, 2 weeks would have been 15th of October. Processing. End of October payment. We are now in December. We are not in the payment. Payment is between both of you. We are in when you are saying that you haven't received a copy of the order, when it is part of CCMS. It is not required. It's not required, Mr. Ramesh. You don't need to waste money on certified copies. Effort to better. Oh, then wait. Certified copy illandre bill process madalva. Print out tegidre agalva. We insist on certified copies. Appeal or not. Advargu illa. But you are getting the order in, and you should process it. What have you done in this? It is not required for the petitioner to produce anything. It's permitted to furnish. Permitted to. Is the additional safeguard. Kodbeku anta henilla. Is directed to furnish alla. Permitted to. There should not be a splitting of hairs on this, Mr. Ramesh. Once you are on CCMS and once you get the order copy, you have to act on it unless you file an appeal. You are entitled to file an appeal. If you don't file an appeal, you have to act on it. You can't say, I'm waiting for certified copy.
That was the mindset.
That has to change.
That's only changing.
That has to change. QR code is there. Code scan madre, you can verify. Then problem is we are not on that. If you are having any trouble, any problem, please tell us. If you have a CCMS login credentials, you are receiving the copy which you can act upon, then there's no need for you to insist on certified copy, one. And there's no need to wait. All these e-governance facilities which are being made available is for faster processing.
They have to come with this. Everything on the, if it is put on the legal section, that's not the
Legal section has to forward it to the concerned section. Legal section is BBMP, entire legal section. They have to act on it. The emergency situation. But if once you get the order, you can send it to the concerned department. They can act on it. ಪ್ರಾಬ್ಲಮ್ ಏನು ಇಲ್ಲ ಅಂತೀರಾ, ಬಟ್ ಏನು ಕೆಲಸ ಆಗಲ್ಲ. So Ramesh, proof of the pudding is in eating it. Unless it is acted upon, then there is no point in saying no problem. There is problem. If there is any particular setup which is required, any modification required, you can bring it to our notice. If we can direct, we'll direct. But you cannot say, I'm waiting for certified copy for 2 months. That we can't accept. It's unacceptable. You have sent it. So we'll record your statement that you are able to access CCMS, you are getting the copies, and you are forwarding it to the concerned department for action as a regular process. He is so-and-so head of legal cell BBMP. It's personally present before this court. He submits that the CCM court case management system has been implemented in the BBMP. User credentials have been issued to the legal department. And that the daily orders and final orders passed by this court are being accessed by the legal department. Once so accessed, the legal department is forwarding the said orders to the concerned section of the BBMP for necessary action. And that all such orders passed by this court would be implemented at the earliest. The submission is taken on record. Insofar as the petitioner is concerned, petitioner's bills are concerned, he submits that the orders have been forwarded to the concerned section, which is being processed in terms of the contract entered into between the petitioner and the respondent, which shall be completed within 2 weeks. Within another 10 days from today. What about your compliance, AGA? Then AGA seeks for 4 weeks' time to comply with the other directions. Released on 19 January at 2:30 p.m. But note here, so that all the instructions are make full use of it. It's used for the petitioner.
Happy for the petitioner, not my colleague is there.
They're supposed to produce photographs and telephone call records.
Photographs are being made ready, and even one telephone call has been transferred into the CD and it's been produced.
Who appears for the corporation, Mr. Subramani? Yako, you are getting stuck with all these kind of matters. head of the legal rep cell or Odra. We could have told him now. There are not here. Pavan, if the head of legal cell is outside, just call. Now that you are here, we thought we'll brief you on these matters also. There are a lot of matters where 248, 1, 2 and 3 are done. Confirmatory order admelunu construction nadita ide. Despite orders being passed by this court. In another matter, we had to initiate criminal contempt. In this matter, Subramani will brief you on this. In this matter, there is serious allegation made.
Government section. Article call ಮಾಡಿ ಹೇಳಿದ್ರು ಆರ್ಟಿಕಲ್ ಇಂದ ಕೊಟ್ಟಿರೋದು ಸಿಟಿ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡು ಕೇಸ್ ಬರ್ತದೆ ಅವರು ಆಮೇಲೆ ಇನ್ನೊಂದು ಏನ್ ಹೇಳಿದ್ರು ಅಂತ ಅಂದ್ರೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾರೆ ನೀವು 24 hours ಕೂರಕ್ಕಾಗತ್ತಾ ಅಂದೇನಿದೆ ನಾನು ಹೇಳ್ತೀನಿ ಅವ್ರು ಮಾಡ್ಕೊಂಡ್ರೆ ನಾನೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಇದೇ ತರ ಅದು ವಾಯ್ಸ್ ರೆಕಾರ್ಡಿಂಗ್ ಬಂದಿದೆ ಸುಮ್ಮನೆ ಅದನ್ನೇ ನಾನು ಸಿಟಿ ಮಾಡ್ಕೊಟ್ಟಿರೋದು
ಏನ್ ಮಾಡೋರು ಹೇಳಿ every day we get at least around 6 or 7 matters like this. Shortage of staff. Is it on record? Shortage of staff.
We have to look after the entire ward.
Shortage of staff. Shortage of staff and the vacancy is not filled. You need more than vacancies.
Wherever sanction plan is issued, and there is a violation of sanction, ADTP and assistant engineers are held responsible. They have to verify. And wherever without the sanction plan being constructed,
You have done internally whatever you want to do. How does the petitioner know? Them it is a corporation. So the help desk or help desk ideyalli. Okay, you can tell them contact so and so and contact ಮಾಡ್ತಾರೆ. ನಾನು ಏನು ಮಾಡಲಿ ಹಿಂಗೆಲ್ಲ ಹೇಳಿದ್ರೆ
ಆಮೇಲೆ ಅವ್ರು ಹೇಳಿದ್ರೆ ADPS ಮಾಡುತ್ತೆ ಸರ್ ಅವರು
ಆಮೇಲೆ ನಾವು ಹೇಳ್ತೀವಿ ನಾವೇನ್ ಮಾಡೋಣ BBMP ಅವ್ರದ್ದು ಯಾವ್ದು ಬಂದ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ Even otherwise, if there's a call to the ADTP, should not the ADTP bring it to AEE mugisbeku. There's no passing the buck. Now they're producing all these records. Now after this record, we have to initiate action. You will again get 2 officers short now. ಮುಂಚೆನೆ ಶಾರ್ಟೇಜ್ ಸಸ್ಪೆನ್ಷನ್ ಅಂದ್ರೆ ಇನ್ನು ಇಬ್ರು ಹೋದ್ರು purpose is not served. ಆಮೇಲೆ demolition. Officers take action immediately. This every day we are having so many. ಸುಬ್ರಹ್ಮಣ್ಯ ಅವ್ರ ಪಾಪ 3-4 ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ತಗ್ಲಾಕೊಂಡಿದ್ದಾರೆ. No instructions. We understand his problem, but we have to see this side also. Instruction ಇದ್ರಲ್ಲಿ ಬರ್ಬೇಕು. ಇಲ್ಲಿ they're clear 248(3) ಆದ್ಮೇಲೆ construction is going on. Photographs have been produced. Your officers are not taking any action. The counsel for the petitioner is produced. Have you given the CD to them? ನೀವು ಕೇಳಿಸ್ಕೊಡಿ. ಅವ್ರನ್ನು ಕರೆದು ಕೇಳಿಸಿ. It's produced certain photographs and a CD. It to be a recording of the telephonic conversation between the petitioner and the assistant executive engineer. The head of legal cell, BBMP, who is before this court, has been apprised of the matters coming up before this court, more particularly as regards unauthorized and illegal constructions and the continued construction post the confirmatory order under subsection 3 of section 248. He submits that these aspects will be brought to the notice of the Chief Commissioner for initiation of appropriate action. And insofar as the present matter is concerned, he'll verify from the call records and provide necessary instruction to Sri M.A. Subramani, Learned Counsel, appearing for respondent number 123. Previous turn. December.
The entire proceedings have been conducted against the person that died in the year 2010. Seven. Five action taken is everything against a dead person. In fact, the notice issued, the page number 200 and 159.
The order is passed against decorative homes.
Decorative homes with the tenant and man.
Yes.
And I am my predecessor in title, who was the original owner of the property, died in the year 2007. Then in 2010, the family members released it in favor of the mother, the wife of the deceased, who in turn gifted it to the first two petitioners here in the year 2011. Ever since then, all the municipal records, Kata, taxpayer receipts, all stand in the name of the petitioner.
Who was the 321 notice issued to?
It was issued to one of Mr. Malhotra, who died in 2007.
Where is that notice?
That notice is at page 159. Relevant portion is on page 160.
248. It was issued on 21/6/22.
Yes. On 21/6/22, in respect of a dead person who died in 2007, a notice is issued.
Suraj Malhotra, Shanti Lal.
And then there is no such address in the record. The incomplete record. Little effort to find out which Kata student would have, and they maintain those records.
Suraj Malhotra expired in 2007. Where is the death certificate?
Death certificate is the and we are not reference is found at page 40. Whereas Suraj Malhotra subsequently died interstate on 8/10/2007, leaving behind his wife, the donor and his children.
Death certificate is also issued by you. Yeah, that doesn't mean you have to issue notice to a dead person.
Yes.
Who died in 2007, 16 years ago.
Your lordship may say page 128. Even the contempt is against the dead person. The writ order, which is at page 128. The respondent filed.
The others are also there.
Yeah. Others are
Sheetal
all there.
Malhotra, Kamna Malhotra.
None of them are.
Dal, Shilpa, Suresh. They are not parties. Our 5, 6 are deleted at risk of petitioner. So it's not binding on them. Anyway, it can't be binding on a dead person. Where is it? For the owners of this property,
Owners of this property are petitioner on it.
where is the Kata?
Kata is at page 59. This is as of your lordship will see the notice. It is on date 2012. 16
Name of Sheetal Malhotra and Kamna Malhotra. Not in the name of Ansaraj Malhotra.
This is maintained by them.
All these documents are issued by you, but one department doesn't know the other. Kata bere, tax bere, 248 bere, plan sanction bere. If you input this property details, you will get everything. So issue fresh notices to them. The Katedar, who is there?
The premises between 2010 and 2006. But the property
Instruction required. What instructions do you want? You have issued a dead person. Writ petition, they have made them a party what to do, and they have been deleted at the risk. They deleted a dead person. That cannot anyhow to their benefit. You have to bring it to their.
I will not say, we will bring it to the notice of the contempt court also.
Take action against people who are alive and who are the owners. Take full action against. Any action has to be in accordance.
In the light of what is happening here, they have tested to make that.
Whatever it is, issue notice to them. Give out the details. Take action. But we are directing you to take action in so many matters you are not taking. And here you are taking action against dead person. Petitioner is before this. Shri Pawan Kumar accepts notice for respondent number 1 to 3. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that an order of demolition under section 356 of the BBMP Act 2020 has been passed without a provisional order has been passed against a dead person without a provisional order under subsection 1 of section 248 or a confirmatory order under subsection 3 of 248 having passed against the petitioner. A perusal of the Kata certificate issued by the BBMP on 15/2/2021 indicates that the owner's name is Sheetal Malhotra and Kamna Malhotra, that is the petitioners herein, whereas the notice issued under subsection, where is that page number?
159.
The confirmatory order under subsection 3 of section 248, as also the provisional order has been issued. Provisional order under subsection 1 of section 248 has been issued on 6/6/2022 to Ansraj Malhotra, certain others. The confirmatory order on 21/6/2022 has been issued to Ansraj Malhotra and certain others. It stated that the said Ansraj Malhotra expired on
8/10/2007.
8/10/2007. And as such is neither the own Katedar nor the Anvodar of the property. And notices and alleging that notices have not been replied to, the order of demolition could not have been passed. In that view of the matter, I pass the following order. Writ petitions allowed as certiorari is issued. The confirmatory order, you not challenge those orders. The demolition cum eviction order dated 21st November 2023 at Annexure A is hereby quashed. Liberty is however reserved to the respondents to initiate fresh proceedings under section 248 against the Katedars, that is the petitioners herein, if there is any deviation or violation of the plan sanction. The AG exception for respond number 1, Pawan Kumar for 200. Yes, sir. Now there are CCMS. So about 2010 matter idu.
But the challenges, the contesting, one of the challenges is election DMC representatives of the Grand Panchayat after 25 years of passing of election DMC without even filing an application to the combination of village. That is one wrong.
Who is appearing for the respondents? Nobody is here. Raj, Pradeep, KP Bhuvan. Bhuvan is the contesting.
Suits are pending.
We'll have it on another day. Though counsel for the petitioner is present, none appears for the respondent. None were to appear for the respondent on the next date of hearing. The matter would be taken up for consideration on the basis of the submission made by the counsel for the petitioner. Relist on 14th December. Application pending idea. Released on 15th December. What is civil amenities?
this became the street lighting, roads, etc. So far, the petitioner's case is concerned. Saying that is an exempted entity under 110 of the Act. 101 of the Act exempts, but 110 says that except service charges your property tax your exempt, but service charges your right. What he said is relying on the judgment of dishonorable court, which judgment have produced an annexure R1. He's referred because I thought it easy to produce. I'm not going to see his state, his repetition. Can you see the repetition? Page number 13. Page number 13. Paragraph 14.
Yes.
Some is a way to consider that in similar circumstances, the dishonorable court in WP number so and the matter of senior superintendent have held that delegate service charge is illegal, held that the service charge has been as tax. This fact was brought to the because insofar as this judgment is on this.
You go ahead.
What he says is that because that he's a charitable institution, then 110 he is exempt because he is exempt from property tax. He has to be exempt from service charge also.
What does the judgment say?
Well, that puts the judgment relying on 285 of the Constitution. The judgment level connection R1 based on the approach. That was filed by the post office.
Yes.
The action that was taken was that under Article 285(1) of the Constitution, property of India is exempt from any kind of tax or levy by the state government or by any corporation or any local authority in the state. So there the convention that was taken by BPM is that you are free only from property tax. The exemption applies only to property tax. It does not apply to service charges. Then my lords were pleased to look at the AMC Act provisions and hold that section the rule 7A, which is inserted, which is coming under the charging section of 103 of the Act. So 103 of the Act actually deals with property tax. Because it deals with property tax, the exemption would also be hit by Article 285 of the 285(1) of the Constitution. But the relevant point will find that page number 41.
Yes.
Nomenclature service charges does not make it
Municipal corporation.
and it's more.
So your contention is despite the exemption under subsection 1 of section 110, under subsection 2 of section 110, service tax has to be paid, service charges have to be paid.
That was the case, my lords, where the my lords have 110.
Yes.
Exemptions. The following buildings and land shall be exempt from property tax. Lords, he says that he comes under C. Cases used for charitable purpose for the purpose of sheltering the district animals, so on and so forth. Is coming under C. But we now kindly see 2 minutes.
Yes.
Notwithstanding the exemptions granted under this section, it shall be open for the corporation to collect service charges for providing civic amenities for general and special services rendered at such rates as may be prescribed.
So yearly charges or once?
Yearly.
Yearly.
He has to pay. Property tax is exempted. He has to pay 25%.
You want to charge 25% as service charges. On what?
The quantification of that service charge is on the property tax. How we are quantifying it, my lord will find that rule 7A.
So you are charging 25% of the property tax as service charges.
Yes. For a normal person, he pays property tax as well as service charge. So, just to put it in a perspective. So,
That is service charge being in only property tax.
this property tax, property tax is one portion. Service charges there is a separated. Like for example, solid waste is solid waste.
Cesses and
So service charge that is separated.
yes.
That is separated. So effectively, what happens is that if it's a person like me who has to pay tax, I will pay 100 rupees as property tax. I will pay 25 rupees as service charges. I will end up paying 10 rupees as solid waste. So totally my tax will come up to 132. Whereas insofar as the petitioner is concerned, the petitioner will only pay 25 rupees. He will not pay the 100 rupees. He is exempted from 100 rupees and 100 rupees. He is not exempt from service charge. So this aspect my lords have already considered in another judgment. There's another judgment of Provisional Court, Dharwad. I have produced the judgment. My lord will find that page 14.
Yes.
But there they had challenged the constitutional validity of 110.
Subsection 2.
Yes, subsection. Sorry, subsection 2. There we should repel the challenge, saying that insofar as paragraph number 5 is 48. Petitioners cannot challenge the service tax on the ground of legislative incompetence. What is to be looked into are facilities and services provided to society in the pool in which institutions established. The amenities, the street lights, public road, hospital, canteen, park, drainage system, etc. are provided, and the petitioners are also users of the amenity and facility. They cannot challenge when a part of the service charge is illegal. The petition has to be dismissed for the reason that while challenging the constitutional validity of subsection 2 of the Act, the petitioners have not stated or taken a ground as under which the statute provides for exemption from property tax, and if the same statute provides for enables the authority to collect a service charge, the same cannot be said to be unconstitutional. For institutions, municipalities, corporations, electrical supply companies, public health engineering departments have been established to render service to public in all aspects of safety and security, etc. And in order to meet to provide these facilities, every individual, more particularly institutions such as the petitioner, have to contribute by way of a nominal tax as service charge under subsection 210 of the Act. Here, the petitioners cannot challenge the service tax on the ground, and the petitioners have not received such a facility from the society or state. What the petitioners have to look at is what should be their contribution to provide facilities and amenities to society as a whole. These institutions are part of the society, they are part of the establishment, which is qualification, but at the same time, they're getting huge chunk of the benefit from the society by way of service and anything. The case of the petition manager to see the feelings. When you are exempting the other 110 from property tax, that exemption is automatically applied even for service charge. And he relies on the judgment of the other judgment which I just read. And on that basis, he says that you cannot do.
There appears to be a conflict between both the judgments, and this judgment was not considered. 4th August 2010 was not considered in the 5th November judgment. You are right under 258, but in para 28, and the reasoning given is that once there is the exemption granted, service charge being sought to be levied on 25% of property is clearly a demand which can only be characterized as tax. The vague indication that is collected towards services rendered in providing civic amenities is not in respect to any particular special service provided to the petitioner in order for this so and so. There's a finding that it is a tax. This judgment was not brought to the notice of the other coordinate bench.
So,
It's not been
if it's
referred
not
to.
considered, then my lords have to automatically. Maybe this submission. So I see. As far as the judgment of so as a post office is concerned, that's under there is a
It's also. You can't say it is only because there's a detailed consideration of this aspect.
I quite see. So my lord, the way I understood it is that the judgment, the second judgment is that judgment says that.
So we'll have to refer it to a bench to consider both these decisions. Because both are no per incurium, both have decided on two different aspects which are bearing on this particular matter.
Then one was not considered my lord by the first by the
Been considered.
101 was not. 110 But my lord, because I have the judgments which are right on by that court also. I read you. This is a case where there is an exemption, partial exemption granted in 110.
Para 3, it considers it. 285, 110, 1J.
Then 1J is for settle. That was read with.
Yes. The two judgment is not for us to decide which one to follow. It will have to be decided by a division bench as to which one will apply this.
Permit me to assist. Give me one piece that it is similar. I saw how I understood because my thinking was right when I tried to the matter. My thinking was that this is a judgment which has to be seen only under the lens of 280. But then 285 exemption also follows on 110J.
110.
So therefore, without reading down 110J, 285 can't be. That's the
Yes.
but we need weeks time.
We'll give you a week's time. Get ready with that. See, the problem or not the problem, the situation is that 110.1 is the exemption provision, including 110.1J. Once the exemption has been granted under that, subsection 2 says 25% service charges for special, including for special services. Now, in the first judgment, the aspect of 110.1J, special services, and whether the impost under subsection 2 of 110 is a tax or a fee or a charge has been considered. And it's been categorically said that it cannot be a charge, it's a tax. So if it's a tax, it cannot be notwithstanding. So a tax will have to have independent existence and independent powers. Once it is exempted under 110, and if there is no tax, the service charges which has been held to be taxed in the first judgment cannot sustain because there is no base for it, which has not been considered in the second judgment, where there is a challenge made to subsection 2, and the other coordinate bench, which is not this judgment was not brought to its notice, held that that challenge cannot be there because there are amenities which have been provided.
I know what. But in my statement of objection, I give a contention that it's not my statement of objection, my lord will see. I have in fact taken a contention that it is not tax. But then when preparing for the matter, I realized it is tax.
It is tax.
Tax.
So once it has been held to be tax, the second judgment which has held it to be not a tax
That's a safe.
It virtually proceeds on that to say, not in so many words, but it says that para 5 that is part of service charge. The aspect of tax has not been considered in the second judgment.
Just so that I can assist the board.
We'll give you some time, but it probably has to go to the division.
No, but even if it has to go to division, it just want to assist
Formulate the questions if you want. Both of you could formulate the questions to assist us.
Essentially, granted under 110. Can it be taken away under 102?
Not that way. If tax is exempted under 110(1), can another tax be imposed under subsection 2? Because in the first judgment, it's been held to be a tax. You may be right to some extent to say service charges could be imposed. But once a coordinate bench has held that to be a tax, now tax on a exempted tax is what you are calculating. 100 rupees, what you are saying is the tax which is exempt. You are now levying 25 rupees on 100 rupees. That is exempt. If it is a charge, you are right. But this court has come to a conclusion that it is not a charge, it is a tax. Can you levy a tax on a tax? You can levy cess, etc. But having come to a conclusion by the coordinate bench, having come to a conclusion that it's a tax in the year 2010, you cannot levy tax on tax. Interest on interest to illa, tax on tax barade. Double taxation ago. Arguing for some time, Shri Ajay Jain and Ajay. You again, Ajay Jain and Ajay Jain and Dalke submit something. Shri Ajay Jain seeks for and is granted a week's time to make his submission. Heard arguments of Shri Prasad Hegde and Shri Ajay Jain. Shri Ajay Jain relies upon, Shri Prasad Hegde relies upon the decision of this court, coordinate bench of this court dated 4th August 2010 in WP 9965 of 2007 to contend that the levy under subsection 2 of section 110 of the KMC Act 1976 has been held to be taxed by this court. And as such, once there is an exemption granted for educational institution under subsection 1 of section 110, the question of levy of tax under subsection 2 of section 110 would not arise. Shri Ajay Jain, learned counsel for respond number 1 and 2, by relying upon the decision of another coordinate bench of this court in dated 5th November 2013 in WP 22780 of 2005, submits that the constitutional validity of subsection 2 of section 110 has been upheld, thereby permitting and or entitling the corporation to levy service charges in terms of subsection 2 of section 110. On being pointed out that there is a probable conflict between both these decisions, inasmuch as in the first decision, the impost under subsection 2 of section 110 has been held to be tax, whereas in the second decision is based on the impost to be service charges and not tax, since the earlier decision had not been brought to the notice of the latter coordinate bench. The Ajay Jain seeks for and is granted a week's time to make his submission on whether this matter would have to be referred to the division bench or not. If so, what are the questions to be referred to? Released on 13th December at 2:30 p.m. for further hearing. Released on 7th December. Interim order 71 alli interim order extended. Released on 7th December at 2:30 p.m. Balar. Has been twice for consideration in the above matter. Petition stands disposed. The respective authorities to act on the joint survey.
My lords, I appear on behalf of the petitioner in the matter.
I'm for the respondent, your lordship.
Yes.
Lordship, the matter may be clubbed with along with 4485, lordship. Same matter.
85.
4485 of 2022, your lordship.
Connect
My
with
lords, such copies served on us.
Yes.
My lords, I'm not informed about WP 4485, my lords. I don't know what the matter is.
I will furnish the copy, your lordship.
What copies are not furnished?
He'll furnish. Counsel for respond number 7 is directed to furnish copy of WP so and so on the counsel for the petitioner in the present matter.
Please, your lordship.
23rd January.
Much obliged, lordship.
Much obliged, my lords. Interim order may kindly.
Interim order earlier granted is extended till next date.
Please, my lords.
One nimsham. Executive engineer BWSSB is held sufficient as refused. AGA. DNA endorsement. Assistant Executive Engineer BWSSB Jayanagar Bangalore service is held sufficient as refused. 75. Mr. Munish, BWSSB. Munish Kumar.
Please, Lords, please, Lords.
It's been refused.
Lords, I'm sorry, please, Lords. I let them send me a copy, please, Lords. I will take it up.
Shri Munish Kumar is directed to accept notice for respond number 5. He is also directed to file an affidavit of the Assistant Executive Engineer BWSSB as to in what circumstances the notice was refused by him. Based on so and so date.
Yes,
Appearing for petitioner, my lordship.
Yes.
The lordship senior is appointed as the HCGP. Kindly delete the name of Mudukangoda R. Patil.
You will appear.
Yes, my lord. I am appear, my lordship.
You will appear. Delete my name.
Out, sir.
Nim vakalatnama idea?
It is, sir. Prabhu L.
Registry is direct delete the name of Shri Mudukunda R. Patil as that appearing for the petitioner, and instead print the name of Sri Prabhu L as that appearing for the petitioner who had filed Wakalatnama on 24/3/2022. Yes, ready?
A very short matter, my lordship. The petitioner has made representation to the second respondent, the Commissioner KHQ. The writ of mandamus, my lordship. Kindly direct the respondent to respond number 2 to consider the representation, my lordship.
Not vacant sites. So refuse it. But can you not consider it in seniority for regular allotment? The date will be taken for regular allotment. Petitioner is before this court seeking for the following release. The grievance of the petitioner is that the application which had been filed by the petitioner for consideration of their application for allotment of discretionary sites has not been considered till date. As such, the representations detailed in the prayer above had been filed, which also have not been considered. The BJ Mahesh, Learned Counsel for Respond number 2, submit that the discretionary quota under which the petitioner had claimed has been struck down by this court in in so and so, wide order dated so and so. And as such, the said application cannot be considered under a discretionary quota. The counsel for the petitioner submits that if not under discretionary quota, the application may be considered giving due seniority to the date of the application.
Please, ma'am.
In that view of in view of such submission, I pass the following order. Writ petition is allowed, a mandamus is issued directing the respondents to consider the application filed by the petitioner under the general category, giving due seniority to the date of the application, as and when applications are called for and or sites are being allotted, if all the other requirements are satisfied.
Much okay.
Yeah, action. You go for respond number 2. You have to take action. So you answer is representation. Okay, PWD has to take action. PWD, you have not made a party. They're saying it doesn't. It doesn't come under your jurisdiction. But insofar as issuance of license, it comes under you. Council, ನೀವು ಹೇಳೋದು ಅರ್ಥ ಆಗ್ತಾ ಇಲ್ಲ. Not in your jurisdiction, notice ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತೀರಾ. ಬಿಸ್ನೆಸ್ ನಡೀತಾ ಇದೆಯಾ? It is a violation. You have to take action to stop the business. Demolition ಆಮೇಲೆ ಅವ್ರು ನೋಡ್ಕೊಂತಾರೆ. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that respond number 3 is conducting his business without obtaining a trade license from respond number 2. The counsel for respond number 2 submit that notices have already been issued to respond number 3 and action is being taken to stop the said business since there is no license. His submission is placed on record. Though respond number 3 has been served and the counsel has entered appearance. None appears for respondent number 3 today. In that view of the matter, I pass the following order. Petition is allowed. A mandamus is issued directing respondent number 2 to
I appear for petitioner, my lords. Due to some personal inconvenience, senior is not before your lordship, requesting to adjourn the matter, my lords.
CO TMC, Chief of. The MR Irremated is directed to accept notice for respondent number 2. Counsel for the petitioner to serve 2 sets of the petition along with annexures on Mr. Irremated.
Please, my lords.
Granted 4 weeks time to file a statement of objection. Objections, if any, by 15th January, released on 23rd January.
Objection.
Huh? Not Ashok Naik Alva. 78 Ali. She so and so. New appear agidira.
No, I am appearing for the in serial number 78. I am appearing for the respondent too.
You are not appearing, madam. Mr. Ajit Shetty has filed wakalatnama. Ajit Shetty.
No.
See,
I have filed the wakalat.
You have filed wakalat. You have wakalat filed. ಯಾರಮ್ಮ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಚೆನ್ನಾಗಿ ಹಾಕಿಲ್ವಾ one more ಒಂದು no representation ಇದು double representation. Anyway, Mr. Ajit Shetty has been given instructions. He has made a submission. We have taken note of it. Not a sheet only.
Okay.
Ajit Anand Shetty has entered appearance for respondent number 2. Registries direct print his name as such and delete the name of Sri Ashok N. Nayak as that appearing for respondent number 2. Rakesh, yes.
81 minute. Is it 80? If it is.
You are appearing for the petitioner, Mr. Ravi?
Yes, minute. 81. In 81.
81. Sorry. Mr. Devraj, is there? Yenamma? Copy kotilva.
A copy objection hakidre malad. They have filed objection. Contesting respondent is the first respondent.
Respondent number 4, Devraj or copy kotilvante.
Malad, all they have been served with the notices. Therefore, there was no need for me to serve it. And contesting, malad, it is an election matter. I have questioned the election of the first respondent to the post of Gram Panchayat. On the ground, malad, he has incurred disqualification, means under section 12H, malad. Since he has done work under by the order of the Gram Panchayat, there is a disqualification for being elected as the member. That is the question involved. And the other parties, malad, they are only formal parties.
Yes.
First respondent is the contesting respondent.
You are appearing for first respondent. Ready? AJ ನಿಮ್ ಕಾಪಿ ಬಂದಿರತ್ರಿ
ಎಲ್ರಿಗೂ ಸರ್ವ್ ಆಗಿದೆ. ಆಮೇಲೆ ದೇ ಆರ್ ಫಾರ್ಮರ್ ಪಾರ್ಟಿ.
ಒಂದೊಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ. ಹೆಂಗೋ ಅಜ್ಜನ್ ಆಗ್ತಾ ಇದೆ.
ಸ್ವಲ್ಪ ಡೇಟ್ ಟು ಲಾಸ್ಟ್ ಎಲೆಕ್ಷನ್
Counsel for the petition is requested.
ಸಾರಿ ಅಲ್ಲ ನಾನು ಕೊಡ್ತೀನಿ.
One more set of petition along with annexures to learn AGA and counsel for respondent number 2 to 4. The counsel for respondent number 1 and 1 seeks for and is granted 2 weeks time to get ready and address his arguments. Released on records ಬಂದಿದೆಲ್ಲ.
ಬಂದಿದೆ.
List on 3rd January. Nitin,
My lord, for the petitioners, my lord.
yes,
My lord, this whole matter is my lord. Am I audible enough, my lord?
yes.
My lord, now there has been a construction, my lord, at the Davis Road, Wheeler Road corner edge, my lord. Now what we are claiming is that, my lord, there has been severe.
Then we issued notice under subsection 3, confirmatory order kotte aita. What is the appeal pending? Under which provision? And before whom? For whom is it pending, under what provision? Yar munde ide appeal. Under which provision? 43. Chief Commissioner. So 248(3) agide. I'm already 248. Confirmatory order has been passed. Now it is pending on appeal before the Chief Commissioner.
Oh.
So whatever happens in the appeal, they'll take action.
Please, my lords. My lords, what has happened is, my lord, there was a building violation, and for almost close to 1.5 years, we had done strikes. We had,
248(3) is done.
yes, my lord. It takes a lot
Nothing
of time, my lord. That's
we can
all.
do.
There has been a huge delay, my lord, at this point.
But now it is done. If it is still pending, we could have done something.
Yes, my lord.
Petitioner is before this court seeking for the following reliefs. The counsel for respond number 4 submit that a confirmatory order under subsection 3 of 248 has been passed, and now the respond number 4 is challenged the same by filing an appeal under section 253 before the Chief Commissioner, which is pending in appeal number 69/2023. If that be so, the relief sought for by the petitioner already answered. The Chief Commissioner would pass necessary orders in the appeal and thereafter action taken. But with the above observation, petition stands disposed.
Much obliged, my lord.
Yaudappa? 70?
70.
You want it on? 12th. 12th. What matters are there? 14th? 12th, no. Yes, 84. Rakshita? ಮಾಡಿದ್ದಾವೆ. 3 weeks time is finally granted to counsel for respond number 3 to file a statement of objection. Objections, if any, by 12th January, failing which it will be taken as not filed, relist on 19th January. Interim order earlier granted is extended till next date. Raju? Yes, Mr. Raju. This is a road which has been shown in the CDP already.
These triangle in our college, in Mundial Karnataka,
Hmm.
they know they want to construct a road across the country. One part of the road. Even though in the field they don't need for this for the next purpose with that. We want another day and justification with that.
Is it shown in the CDP? If it's shown in the CDP, you will have to challenge the CDP.
Block the road. They don't want to use this drive. Block my aim
Challenge ಮಾಡಬೇಕಲ್ಲ. Without that, it can't happen. Again, for something that senior counsel for the new memo jote act, so that with the date it will be there. Learned counsel for the senior counsel for the petition after arguing for some time seeks for and is granted 3 weeks time to file necessary application for amending the above petition, challenging the CDP. We list on ನೀವು 2 ದಿನದಲ್ಲಿ ಆಗತ್ತಾ? 2 ದಿನದಲ್ಲಿ ಮಾಡಕ್ಕಾಗತ್ತೆ, ಗ್ರೌಂಡ್ಸ್ ಬೇಕು. We list on 18th January. Interim order earlier granted is extended next. Jagdish Achari. It's complete agide. None appears for the petitioner. 3 weeks time is finally granted to the respondent to file a objection ready by 18th January, released on 25th January. Babu DR. Petitions file ಮಾಡಿದಿರಾ?
But you have to put it in the document so that you won't have that. So the endorsement
Endorsement ಕೊಟ್ಟಿದ್ದೀರಾ?
Then at page number 35.
None appears for the petitioner. Learned counsel for respondent number 2 submits that the application of the representation of the petitioner at annexure B and D had already been considered. D and representation ಅಲ್ಲ ಇದು. Petitioner in the above matter is sought for the mandamus to enter the name of the petitioner in respect of the property covered under Kanishmari number 9/9 with a measurement of 20 into 20 square feet, which application filed by the petitioner has been rejected by the endorsement dated 12/5/2022 at annexure H. And as such, he submits that without challenge to the endorsement, the present petition is not maintainable. None appears for the petitioner. If none were to appear for the petitioner on the next date of hearing, the above matter would have to be dismissed for non-consultation. Amendment ಹಾಕಿದ್ರೆ ಹಾಕಿ.
already completed.
How the work carry out ಆಗಿರೋದು? But work ಯಾವಾಗ carry out ಮಾಡಿರೋದು?
Carry out ಮಾಡಿದ್ವಿ 50% complete ಆಗಿದೆ. About release ಮಾಡಿ.
ಯಾವಾಗ carry out ಮಾಡಿದ್ವಿ? When was the work completed? When was the work done?
Done.
Yes. It's 10 days of the year 21-20. Petitioner is before this court seeking for the following reasons. The grievance of the petitioner is that despite the petitioner having carried out certain works and having raised his invoices relating to such works, payment has not been made. As such, a representation was submitted on 5/12/2022, which has also not been acted upon. If there are any amounts due and liable to be paid, it is but required for a statutory authority to do so, as held by the Honorable Apex Court in Levy Construction versus so and so. This court in so. In that view of the matter, I have passed the following order. Writ petition allowed. Respondents are. Respondent number 2 is directed to consider the representation of the petitioner dated 5/12/2022 and consider the bills which have been raised by the petitioner. Process the same in accordance with the contract entered into and determine the amounts due, if any, within a period of 4 weeks from the date of receipt of a copy of this order, and make payment of the admitted amount within 4 weeks thereafter.
Square meters area has been utilized not for widening of the road. They got the document executed. And the assurance that the criteria is issued. In that confirmation, no criteria.
Where they say that they will issue the TDR? Page 28. Who has to recommend and who has to issue? So, in our recommendation, Agila. Yes, Mr. Monish.
Millards.
Recommendation.
TDR issue, please, Millards. This is serial number 93, please, Millards.
How do?
Millards, just now I have received Millards the copy. I will ascertain from my client, please, Millards, and revert back.
In the very, you have to do the recommendation if you have not done the recommendation.
Please, Millards, Millards will dispose it of on the all contentions kept open, please.
Yeah, within what time?
That's about 60 days, please, Millards. Like last time, Millards had disposed of Millards one petition. the only humble prayer, please.
You take the land and don't give them.
I'll within 60 days.
The most unfair organization.
You go down, please, Millards. I'll ensure, please, Millards, that something works out.
Now you'll have to do it at current rate. That's also, please remember that.
Please, Millards, please. No injustice should be caused to any party. That, Millards, I will request that.
What happens is now the current rate, the taxpayer will pay that money.
Please, Millards.
Of your delays.
For the delays, please. I will ascertain, please, Millards, what has really transpired. Because in some issues, Millards, there will be other issues also which will be keeping us.
For the following reliefs. The grievance of the petitioner is despite the land of the petitioner having been taken over by the petitioner, by the corporation, for the purpose of widening of the road in front of the property of the petitioners. Way back in the year 2016, the transferable development rights certificates have not been issued by the PDA on account of suitable recommendation not having been made by the corporation. It is rather shocking that from the year 2016, the authorities have not, BBMP authorities have not processed the file of the petitioner and issued TDR, even though it was on the basis of such a representation made by the BBMP that the petitioners had voluntarily handed over possession of their land for the purpose of widening of the road. In that view of the matter, I pass the following order. Writ petition is allowed. Respond number. Who is to approve it?
The TDR section.
TDR section yaudappa?
Deputy Commissioner TDR should have been a part.
Respond number 2 to 5 are directed to consider the application of the petitioner and recommend the same for issuance of TDR in terms of the value of the property as on the date, market value of the property as on the date on which such recommendation is made, in terms of made to the 6th respondent BDA to enable the BDA to issue transferable development rights certificates. The recommendation
to be yet kept open.
The processing and recommendation by respondent number 2 to 5 to be made within 60 days from date of receipt of a copy of this order. The issuance of TDR certificates to be made within a period of 4 weeks, 30 days thereafter.
If there's any ambiguity, we will inform the petitioner. That one, all contentious may be kept open.
Needless to say, the petitioner shall comply with all legal requirements and supply all documents and clarifications that the corporation may require.
Deeply applied.
Submit all the documents. Sidramaya?
Appearing for petition. My lord, yes. My lord, objection is filed. My lord, the property situated within the jurisdiction of Davanagere Mahanagara Palike was earlier allotted at page number 10 annexure.
We'll have to hear Mr. Manjunath.
Yes. Please.
Released on 25th January.
Interim order may be extended.
Interim order earlier granted is extended till next day.
Date, my lord.
25th January, Mr. Sidramaya.
Please.
Yes, Mr. Arvi.
Consider the presentation and I take note. For 41. The petitioner's husband who made his application on 18th April 2023. Unfortunately, he died on my order 24th May 2023 my order. Next day, page number 16. In such a way, the petitioners may not make this application. Next day, the application 18th April 2023.
ನೀವು ಆಮೇಲೆ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಾ?
ಹಾಕಿಲ್ಲ ಸರ್, ಇವತ್ತು ಕೊಟ್ಟರೆ ಹಾಕಿ.
Pass an order and give it to them as an endorsement. Why are you keeping quiet? ನಿಮ್ಮ ತಲೆಯಲ್ಲಿ ನಿಮ್ಮ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ನಿಮ್ಮ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಏನೇನಿದೆಯೋ ಅದು ಪೇಪರ್ ಅಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಡಿ. ಎಲ್ಲ ಬರೀರಿ. But don't sit on an application. You may have 100 good grounds, but none of them is a good ground to sit on the application. ಎಲ್ಲ ನೀವೇನೇನು ಇವಾಗ ಹೇಳ್ತಾ ಇದೀರೋ ಅಲ್ಲಿ ಕೊಟ್ಬಿಟ್ರೆ ಆಗಿರೋದು. They could have challenged it or they could have become parties there. They may not even know those facts. Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the application stroke representation submitted by the husband of the petitioner dated 18/4/2023 at Annexure K has not been acted upon. On inquiry, learned counsel for the petitioner submit that the said husband is expired. And as such, if liberty is granted, the petitioner would make necessary application for effecting Kata in the name of the petitioner. In view of the above, I pass the following order. Whenever any application for transfer of Kata is made, issuance or transfer of Kata is made in terms of the Sakala so and so, the said application is required to be acted upon within the process and orders passed within a period of 30 days from the date of application. Either accepting or rejecting the application. If rejecting, by way of a reasoned order. None of them having been done, I pass the following order. Writ petitions allowed. Respondent is directed, third respondent is directed to consider the representation dated 18/4/2023 at Annexure K, along with any fresh representation that may be filed by the petitioner for transfer of Kata in her name, since she claims to be the sole heir. Sole heir. So, since she claims to be the sole heir of her husband, the said application to be considered and necessary orders to be representation to be considered and necessary orders to be passed within 30 days from the date of receipt of the additional representation. Sidramaya.
My lord, wakalat is not filed by the respondent. Objection is also not filed. Yeah, sir.
ಬರ್ತಾನೆ ಇರತ್ತೆ ದಾವಣಗೆರೆಯಿಂದ ಬೆಣ್ಣೆ ಮಸಾಲೆ ತಿಂದು ಬರ್ಬೇಕು. ಯಾಕೆ ಅಷ್ಟು ಲೇಟ್ ಆಗ್ತಾ ಇದೆ ದಾವಣಗೆರೆ ವಕಾಲತ್ ಸರ್? ಇವ್ರು ಎಮ್ಮೆ ಹಾಕ್ಬೋದಲ್ಲ? ಇವ್ರಿಗೆ ವಕಾಲತ್ನಾಮನೇ ಬರಲ್ಲ. And they are also embarrassed to appear without wakalatnama. The counsel for respondent number 5 submits that he is yet to receive his wakalatnama and instructions. Given 2 weeks' time, he will obtain instruction, make his submission. Released on 5th January. Counsel for the petitioner released on 22nd January. None appears released on 25th January.